If you would please rise and join me for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thankfully, I didn't start by saying the Our Father this morning. It's an improvement over our last meeting. I had the Hail Mary this morning, huh? Yeah, let's do it all at once. Sure. Let me start by hereby opening the public hearing on Senate Bill 409 and recognize the sponsor to introduce the bill.
Thank you, Representative Roy. Good to see you. Tell everyone to do that, and I don't do it myself. Senator Bill Gannon, I represent the Wine District of New Hampshire, Senate District 23. And if you haven't visited our wonderful region, we have like 12 wineries in a little place, and there's a bus can take you around. It's just like the movie Sideways. SB 409 for those of you who are movie buffs. Relative to the penalties for offensive disobeying a police officer, really a bipartisan bill. Senator Fenton was going to bring it in. Somehow he didn't, and I did. So they've been having numerous problems, especially the police chief from Keene was the one who had the idea for this bill. And he's had numerous car chases. They don't obey the blue lights. They don't stop. They don't pull over. We've just, across the board, the roads have been rough the last 2 or 3 years. I don't know if it was because of COVID. I don't really know what the reason is. Society, just no one listens anymore. The DUI thing, I can tell you different reasons, but we'll get to that this afternoon. So we were increasing the penalties to try and reel the problem in of people not obeying flashing lights or police officers in motor vehicle chases. So Officer Amatucci can tell you a little more details, but the basic misdemeanor was rising to a B, and the B for aggravated penalties was rising to an A. Yes, Officer, if you want to give more details on the bill.
Yes, sir. Thank you very much. My name is Matt Amatucci. I'm a captain with the state police, and I'm here in support of this bill. This legislation strengthens penalties for individuals who disobey a law enforcement officer and flee during a motor vehicle pursuit. It updates RSA 265-4 regarding fleeing from an officer under subparagraph 1C by designating the offense as a Class B felony and elevating it to a Class A felony if the individual is involved in a motor vehicle accident that results in injury or death to another person. These changes reflect the seriousness of the offense and the danger it poses to the public and law enforcement. The New Hampshire State Police has seen a 123% increase in pursuits since 2017. This trend underscores the urgent need for stronger deterrence. Pursuits are inherently dangerous not only for the officers involved, but also for innocent citizens who share the New Hampshire roads. High-speed pursuits can lead to severe crashes, injuries, and fatalities, creating unnecessary risks for everyone. This bill establishes clear, elevated penalties based on the severity of the outcome. It sends a strong message that fleeing from law enforcement will not be tolerated in New Hampshire. By enacting these changes, we create a strong deterrent to reduce pursuits, protect the lives of New Hampshire citizens, and safeguard the officers who risk their lives in these dangerous situations. This bill is about saving lives and reducing unnecessary dangers on our roads. Stronger penalties will help prevent pursuits before they start, making our communities safer. Thank you.
Thank you, Captain. Thank you, Senator. As you're probably aware, my best efforts notwithstanding, this bill did not fare well on the House floor. And the House generally has a very suspect eye at making things a felony, and rightfully so. Looking at it, is there anything you can think of, different ways that we can think outside the box to make this more palatable, but yet still drive home the idea that this is a very dangerous thing and there has to be a penalty that's commensurate with it, short of a felony? Also, if you know, what are the administrative punishments that exist for someone who fails to stop right now as far as their driver's license abilities?
Yes, thank you for the question. As it is now, you can submit a letter to the Division of Motor Vehicles and request to have a hearing and have their license suspended immediately. that is a process that we have started to do. But it really just comes down to stronger deterrence. If you provide a false name, that remains a misdemeanor. If you disobey a law enforcement officer by fleeing in a vehicle, we don't know what that reason is, but you're jeopardizing lives of innocent people, and there is no reason for it. There's no justified reason for it. There has to be strong deterrence.
Yeah.
You're literally risking people's lives, your family, my family, people that we know for no reason. They're driving well in excess of 100 miles an hour, passing vehicles in breakdown lanes, running red lights. And the answer can't be law enforcement will just back off.
Yeah. No, everyone will run. Yeah.
Right.
Let me ask you this. The what you just said brought something to mind. One of the arguments we heard, though, against it, and it makes a point. A lot of these are kids. They're anywhere from 16 to 18, 19. They really aren't. They don't think the implications of a felony for what it's going to have for the rest of their lives. Do you know what percentage of the people that actually are running, what their demographics are?
Thank you for the question. I don't know, but I think that starts with education. I think that starts with notifying the public, educating the public, starting in driver's ed early on. I know that driver's ed programs do a good job of showing fatalities, and not to be real gruesome, but this is the reality of life, and you have a great responsibility when you're giving a driver's license. You're driving a deadly weapon.
Yeah.
In every instance, it's the manner in which it's intended to be used. In those cases, it is a deadly weapon. So I think it would come down to us really educating the public and using this as a very strong deterrent that it won't be tolerated.
Thank you. Questions? Representative Scheer.
Thank you to the chair. A couple questions. One, you said there's been a 123% increase since 2017. Is that what you said?
Yes, sir.
What are the numbers underlying that? Is it from 1,000 to 2,000? Is it from 2 to 4? I mean, do you have any sense of what those numbers are?
Thank you for the question. I don't have the exact numbers. I believe it was in the 70s, and it has jumped up in excess of 140, 150. But I can certainly get you more accurate numbers if you'd like.
That'd be helpful. Thank you. A follow-up? Of those, let's say it's 140. Of those, how many involved in injury to somebody?
Thank you for the question. I do not know the answer to that.
Okay.
Can you get us the demographics behind all of this? With reasonably, I mean, I don't want you to have to dedicate too much, but if you could get us the demographics, age, injuries resulting, and if you know the outcome of the disposition of the charges, it would be helpful for us to kind of figure it out. Representative Muse.
Yes, sir.
A question I always have when I see bills like this, and I kind of go back to that old saying, if a tree falls in the woods, does anybody hear it? So if we pass a penalty increase in this particular committee, how do we get the word out to people who are in the situation? And I mean, raising penalty sounds good, but in terms of the effectiveness, in terms of actually changing the behavior, are there other things that we need to do too?
Yes, thank you for the question. It's an excellent question. I think we would do a lot of things through social media, radio stations, to publicize that. But it comes down to, and I don't have any firm data on this, but in speaking with people, individuals are now saying that the reason that they run is because they've heard that police don't chase anymore. And a lot of agencies, they have their own policies, have gone away from it because of the risk versus reward. And it comes down to, it really depends on what town or city and the population and what that looks like. So I think a lot of individuals they look at it like surrounding states have gone away from it in some instances. And some local agencies have gone away from pursuits. And that is the reason why they run. They look at it like risk versus reward as well. If I run, what are the odds are that they are going to chase me? And what are the odds I'm going to get caught? And then what do I have in this vehicle? Or what is the reason I'm running? Is it because I'm a habitual offender? Is it because I'm intoxicated? Is it because I have illicit drugs? It's probably not for the speed that they're running. So I think there's a lot of unknown variables, unknown factors. But one of the main reasons why we've seen an increase, I believe, is because the lack of consequences, starting with, I'm not going to be pursued.
Yes, just before it slips my mind, in the demographics that you're going to look up, if it's possible, how many people that ran that you ended up getting had attached plates that weren't the plates that should be on that vehicle? It brings me back 30 years, but we always used to say you cannot run a radio. And if you get the plates, follow up, Representative Means.
Just looking at the particular statute that we're changing, 265:4, one of the things that I see is that there actually already is a Class A felony penalty for somebody who causes the death of a person in an incident like this, and a Class B felony for somebody who causes a serious injury for something like this. While combining them both, I guess, to create a Class B felony, or Class A felony, which is what this particular bill does, I can sort of see the point of it. Also noticing that the basic offense is an unclassified misdemeanor, which means a judge would have the option of not only fining a person, but also of sending them to jail if the offense was serious enough. I'm just wondering, what does this bill really do? I mean, the penalties already seem pretty severe, and maybe we're making them a touch more severe, but I'm not seeing any kind of a quantum leap that would, it would seem to get the attention of this sort of core group of people any more than the current statute does.
Respectfully, I would disagree. I
Okay.
think that there's a significant difference between a misdemeanor and a felony, and there's a lot that goes with that. And I think in this very specific instance, when you run from law enforcement, there should be stiff penalties. You are risking countless lives every single time that this happens, and there have to be strong, swift penalties. The administrative side of the house, we're making changes, but that just deals with your license, and that, are you going to stop driving? That's a privilege to drive, but there has to be strong criminal penalties, and I think that this bill demonstrates the severity and the seriousness of this offense if you flee from law enforcement.
Thank you.
Was any thought given to stratifying it a little bit? In other words, if you ran from law enforcement and you exceeded 100 miles an hour during that, making it more serious than versus otherwise? I mean, there's different levels within this type of behavior, between a kid, just trying to get home 3 streets and doesn't go above 50 versus a guy who jumps on 93 and is doing 120 trying to cross the state line. And also into that question, it used to be my understanding that you could pursue across state lines only for a felony. If running from the police isn't a felony, you have to stop at the state line. Is that correct?
Thank you for the question. In Massachusetts, yes, for felonies only. In Vermont and Maine, if it's suspected DWI or a felony. So it just depends on what state you're crossing into.
You mean
on
as
the-
a New Hampshire trooper, you can go
Correct.
into. So you can't cross into Mass unless you're pursuing for a felony.
Correct,
But in Maine, if it's a suspected OUI, but if you don't know what it is,
correct.
Can
You would
you
have
not-
to have operation, you'd have to be able to articulate your reasoning for suspecting that it's DWI or that it's a felony.
would that come up in an extradition hearing?
It could,
Okay.
yes.
Representative Scheer.
Just to follow up on my question about the 123% increase, let's assume it's somewhere around 70 to somewhere around 150. Is that in the 9 years since 2017? When 2017, the entire year there were 70, and now in the entire year of 2025 there's 150. Is that how it works, or the total over those 9 years?
Thank you for the question. Yes, to clarify, it's per year.
Got it.
And we've seen a gradual increase since 2017 in pursuits.
So, so you're saying that in 1 year we had over 150 pursuits?
Approximately. I'll get the accurate data, but yes.
All right, thank you. Questions? Anyone else? Yes, Representative Sills.
Thank you. Thank you for taking my question. Recently, we've seen the impact of technology in automobiles. And also, we know that a person who's been convicted of DWI sometimes has to put in a code that would restrict them from driving if they're impaired. I'm just wondering if you know of any technology that would enable a policeman who's in pursuit to push a button and disable the car.
So thank you for the question. Not to my knowledge that law enforcement has those capabilities. I think manufacturers have those capabilities, but that's not technology that I'm aware of that law enforcement has access to.
I think you're thinking of the NSA, Rich. Actually, I did see there is a sled that you can launch off the front of the cruiser that goes underneath, and it does an EMP type deal and fries everything. Just in case you're wondering, that'll never pass the house. Yeah, but I like the futuristic thinking. Did you have a follow-up, Rich? Okay. Any other questions? Yes, Representative Murphy.
Thank you, Mr. Chair. Thank you for taking my question. I know I've spoken with the police chief in my town at length about this, and he's very concerned as well. And in fully recognizing that it doesn't take, I mean, within a week, we see things in the newspaper, hear it on the radio, that public safety is at risk by drivers like this. That said, as Representative Roy said, this didn't pass in the past. I'm wondering, and I think some of the concern is about youthful drivers, and another concern that I had myself as a parent of a 25-year-old special needs adult who has a driver's license and a brain injury. And I think of situations where, say he ran a red light, say he did whatever. He's got, frontal lobe challenges. So making a decision in the moment isn't always a strength. And I recognize that some of the concern that we hear is that, well, what about those situations where all he wants to do is get home and he's driving 50 and the speed limit's 30 or whatever it is. Was there any thought about possibly putting in some kind of caveat where unless exceptional circumstances exist, which would allow the courts to decide, rather than have it be a blanket, what do we do, the class B felony. Was that a thought to give a little bit of leeway and a little bit of judicial discretion?
So thank you for your question. I think that comes down to discretion. And I think that the vast majority of prosecutors and law enforcement exercise that. For example, I won't say oftentimes, but there are instances where people don't stop because they're not from this country and they don't know what it means. They don't know what blue lights mean. There's a language barrier. In those instances, oftentimes they're not charged with disobeying. It was a language barrier. They might be cited for the underlying offense, but there's a lot of reasonableness, I think, that goes with with this statute.
Follow up?
Thank you. But when I read the statute, and I recognize that probably happens, but that's not what it says in the statute. It doesn't, the way I read it, it doesn't seem to allow for that. It says, if you violate this, you are guilty of this. So I don't see where that exception is, and I think a clause that would allow that would, I mean, if it's already being done, that's great, but this doesn't say that that's allowed, and I just.
Representative, I think what he's referring to is general prosecutorial discretion. In other words, a prosecutor can decide on any case. It doesn't have to be in a statute. Your point is it might be easier to pass if it was clearly a judicial safety valve were built in. Is that what you're?
Yes, thank you.
And what would be your thoughts on that? If there were some type of a judicial safety valve where a judge could look at it and say, okay, this is obviously just a youthful idiot, for the lack of a better term. He doesn't deserve to be a felon.
Yes.
Do you see what I mean?
I absolutely would agree with that. I think that that's what happens now.
Yeah.
But certainly if the committee felt more comfortable with, a carve out that lays that out, again, that's what's happening now. So I wouldn't have any opposition to those changes.
Okay. I think that based on the experience I had just 2 weeks ago, as it is, it's not going to pass. So I think we're going to work on, we understand the goal and we're going to work to get there somehow. And I think there's a lot of different things that we could explore. So thank you. Any further questions? Seeing none, thank you for bringing us this bill.
Thank you.
Is there anyone else? Anyone else wishing to testify in this bill who hasn't done so? Seeing none, I hereby close the public hearing. Next one is in 5 minutes.
You have is the cadaver next?
Did you bring a cadaver?
What's that? It's my third bill if I go upstairs.
And no, Representative Scheer does not count as a cadaver.
Ooh, that was rough.
At least for today.
Do you
Yeah.
have a 10? So this was 10. Do you have something in between cadaver dogs that,
I've got possession, I got cadaver dogs at 10:30 and then I got,
so that's your next one?
yeah,
I'll just stay here.
okay,
That's the other one. So.
yep.
You guys have time? Can I see you all?
Yeah, it's about making sure people have money like you, because it costs a lot of money. Okay, I'm opening the public hearing on Senate Bill 410, and I invite the prime sponsor to introduce the bill.
Thank you. It's good to see you all again. Now everyone's looking more wide awake. All the iced coffees are gone, and we're still working our way towards the DUIs. That'll be my highlight of the day with you. But right now, we have Amatucci is again going to do most of the hard work for me, so I have an easy job. But they came to me, Beth Sargent, I don't know if she's behind me, the lobbyist, and some others, and they said that right now we don't have a lawful mechanism to train the cadaver dogs because it's human remains. And so they needed it in statute so the dogs can be trained. They have to be able to legally possess human remains. And I'm going to turn it over to Emma. We should have brought the dog. If we had brought the dog, it wins over every room. But go ahead, officer.
Yes, thank you. Again, my name is Matt Amatucci with the New Hampshire State Police, and I'm here in support of this bill. So this legislation establishes a lawful and ethical process for law enforcement to possess portions of human remains and ensure dignity, transparency, and accountability with handling remains. There are several key safeguards that have been put into place. Written consent from next of kin or the individual prior to the death must be obtained. Oversight by credentialed professionals, compliance with health and safety regulations, chain of custody documentation, and responsible final disposition through licensed professionals. So stakeholders have come together to work on this legislation and are in support. This legislation was developed with input from law enforcement, funeral home professionals, and academic institutions. This legislation is recognized as a best practice bill that fills a long-standing gap.
Thank you. Is there any difference between this and the House version that we already passed?
No, sir.
So they're both identical?
Yes, sir.
Okay. Any further questions? Representative Muse.
I'll ask you a question somebody asked me when they saw this bill. When we talk about possession of remains, what exactly are we talking about? Is it a part of a finger? Is is there a way you can be
Yes.
a little more, because I couldn't answer the question.
Yes, sir. Thank you for the question. They will create training aids, and it would be different parts of the body that will be decomposing at different rates. Currently, the aids that are being used are very old, that have been thawed and frozen for years, and our dogs just aren't trained very well. So this would be a mechanism. It could be different parts of the human body, but it would be a very small a training aid that would be created by a professional, and then any policy that is created would be housed over at Police Standards and Training.
Thank you.
Representative Chabon Deschanel.
So I'm curious. So it sounds like the kinds of circumstances at which the dog is training for could be like something as a killing that happened last week to, hey, we're diving into this cold case again from a few decades ago.
Yes, sir. Thank you for the question. So UNH is in the process of creating an area where you can go train in this different ages of decomposition, and dogs would be able to go there and train. So if it is a cold case that's been a number of years, there's an area that they know they would be tracking how long in the different ages of decomposition.
Further questions? Seeing none, thank you.
Thank you.
Anyone else? Anyone else wishing to testify on this bill who hasn't done so? Seeing none, I close the public hearing. Does anyone object to just executing this and getting it off our list? I'm going to suggest OTP and let them just have both versions and they can decide what they want to do. Is that okay? Or
answer just that. And he just said they were the same.
Huh?
He just said they were the same.
They are, if you recall, a couple of years ago, we did this, and since we passed all, I killed all theirs. They were very angry for some reason with that, because they wanted to have credit for some of the bills too. So I don't know which ones they want. I don't really care. I think it. Because at the beginning of the year, say, okay, and when they go down, I decided that year, okay, we'll decide to go there. And they internally care.
Terry,
Yes.
wouldn't it make more sense to just interim study this and sit on it until we see what happens to the House bill?
Yeah, and that is not a
Yeah, but see what happens in the Senate to the House bill. They're gonna pass it.
Yeah, but I was just telling them, this happened a couple of years ago.
I don't think so. If we pass this, they're not gonna pass ours.
A couple of years ago.
Are you serious?
A couple of years ago, I ITL'd all theirs that passed here,
Yeah.
and they were very mad, because then they didn't have credit for passing it. So I was just gonna let them decide which one they want. Here's the thing, if the House, we can strategically pick which ones we want, to let them keep and which ones.
Okay. So
Like this one,
The next one's the same.
we can interim study this.
just like to
I gotta give them something.
Why wouldn't we just give this to them?
That's fine, that's fine.
I don't know
Why
which
do they
ones.
get to make the choice?
Huh?
Why
What?
do they get to make the
Well,
choice?
'cause otherwise they-
Always.
all of the stuff that we bought, they're paying.
Why don't we
He
give them,
wasn't bad. He wouldn't care.
why don't we give them one of these, but not both?
Thank you.
Yeah. Which one?
Doesn't matter to me.
Well, we already did the dog one, so let's just interim study this dog one. And then we'll give them something else.
Give them the search, the inventory.
Yeah. Did we pass it?
Yeah.
Oh, yeah. All right. I'm gonna open the executive session.
You got the mic?
I hereby open the executive session on Senate Bill 410 and recognize myself to make a motion. I move interim study.
I'll
Second.
Seconded by Representative Gathright. As we already passed an exact same version and the witness testified that it was the exact same version, and it should be going to the Senate, we will put this one in interim study just in case something happens. I don't anticipate it will, but given that, I don't think we need to pass two of the exact same. So any discussion? Seeing none, I'd ask clerk to call the roll. The motion is interim study.
Representative Lynn?
Yes.
Representative Prue?
Yes.
Representative Lascelles?
Yes.
Representative Devoyd?
Yes.
Representative Paquette? Yes. Representative Saborn Deschwinier?
Yes.
Representative Harry Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Shear?
Yes.
Chairman Roy?
Chair votes yes.
13-0.
Any objection to consent? Seeing none, I'll go on consent, and I close the executive session. Anybody open the executive session on Senate Bill 411? Invite the sponsor. to introduce the
Senator
bill.
Roy, I am still Senator Bill Gannon from the wine country of District 23. Come visit Servino's and I'll show you around. It's not an ad, just like it's a little joke. Anyways, I'm here to introduce SB 411 relative to the procedure concerning search warrant inventories. From what I understand, it's more of an administrative thing to cut down on having two law enforcement people testify to guarantee what. Anyways, I'll let you do it. You're here. If you didn't show up, I'd have to do it, but you're here, so.
Good
why work
afternoon,
hard?
Mr. Chairman and members of the committee. Thank you for taking my testimony today. My name's Tamara Hester, and I'm a lieutenant with the New Hampshire State Police. So the purpose of the amendment to this bill is more specifically related to who is the individual that is signing the search warrant return, as well as whether there needs to be a witness present for the service of remote service of search warrants. So just to give a little bit of background, I'm sure as everyone in this committee knows that technology is part of our everyday lives, and part of criminal investigations is doing search warrants to electronic service providers and internet service providers, Comcast, Google, Snapchat. They are the keeper of the records. So the first part of this amendment is going to be who prepares the inventory. So currently that the bill, excuse me, the statute says that the affiant for the warrant signs the search warrant return. So in modern day cases where we're generally writing search warrants on computers now, as opposed to previously when they were being typed on typewriters or over the phone, the affiant for the warrant is not actually always present at the execution of the search warrant. Specifically in major cases such as homicide investigations, the affiant may be writing the search warrants at another location, and a team of crime scene personnel or other law enforcement officers are actually the ones executing the search at a residence and therefore leaving the return. So it would just say that any law enforcement officer is capable of signing that return. Just to provide a secondary example to that, which is also common, is service of a search warrant for blood. So oftentimes, a crash occurs in a certain part of the state, and the person may be brought, multiple counties or towns over. So it's more practical for another individual to actually be serving the search warrant to that location. In both of those situations, specifically, those would still require a secondary witness to the search warrant return. The second is related to the electronic warrant service, that meaning, like I said, banking records, electronic service providers, internet service providers. Right now, the way that the statute is written, it doesn't reflect modern workflows. So most electronic service providers actually require the service of a search warrant through their law enforcement portals. And we as law enforcement and the courts actually rely on the electronic service of search warrants for filing both the warrant and the return, so the inventory procedure can closely align with that process. And specifically for warrants involving electronic service providers, remote searches, a witness really isn't practical, because all it would be is them hovering over your shoulder to watch you upload a search warrant to a law enforcement portal, of which in those scenarios, there is an electronic trail, right? So there's the uploading of the warrant, there's an email from the electronic service provider saying that, you have records to download, and then you're downloading of the actual records, and those providers also say this is a certification of the records that are related to this case, because they are the keepers of the records, as opposed to law enforcement going to the house and seizing physical items. So that that's my summary of those. So again, for electronic service, only a single witness would be provided, but where physical items are being taken pursuant to a search warrant, a witness would still be required.
As you, I'm sure, are aware, the House passed an exact same version of this. Is there anything different in this one than the one that we already passed?
No, I believe the language is the same.
Okay, great. Thank you. Any further questions for anyone? Seeing none, thank you for your testimony.
Thank you.
Any other witnesses? Anyone wishing to testify who hasn't? Seeing none, I hereby close the public hearing. Let's, if you guys want, we could exec and OTP this one. I hereby open the executive session on House Bill 460, oh, no, that's not it, 411. And I recognize myself to make a motion of ought to pass.
Second.
Seconded by Representative Prue. Any discussion? Ah, very good. I like that. That's good. Seeing none, ask the clerk to call the roll. The motion is OTP.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative LaSalle's,
Yes.
Representative DeWard,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gothright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy, 13-0.
13-0. Motion, any objection to consent? See none, will go on consent. I close the executive session. Opening the public hearing on Senate Bill 460 relative to the offense of loitering or prowling, and invite someone to introduce the bill. The sponsor, Claire.
On now? Thank you. My name is Claire Roulard, and I am here on behalf of the Senate to introduce Senate Bill 460 FN relative to the offense of loitering or prowling. I am not here to testify to the bill. I'm here merely to introduce it because of the logistics of the buildings and the committees. There's no testimony that was given to me to hand in. There is someone here that does have an opinion on the bill. I probably have an opinion, but I won't give it. Thank you.
I'm not sure if we appreciate that or not.
I think you would appreciate it.
I want to express my deep disappointment that the Honorable Ms. Rouillard is not willing to take questions.
It is so noted.
I'm smart.
Will you introduce yourself?
Yes. Good morning, we're still in morning. Good morning, Mr. Chairman and committee. I'm Lieutenant Mary Ketterberg. I work for New Hampshire State Police. I oversee Records Information Services, which includes the Sexual Offender Registry. In reviewing this bill, there was a couple of things we looked at for amendment side of it and removing, leaving just schools and childcare, taking out churches and taking out any other place a person may be, and having without a legitimate purpose added into that bill, I think is important to do. Having without a legitimate purpose, knowingly or remain within 1,000 feet of a school or a childcare center. So that doesn't account for anybody that's walking by or going to have dinner somewhere or lives near a park or anything of that nature.
Thank you. Can you, now that we've had a chance to experience this bill once, this is the second go around, obviously we need to change something. So one of the things that's a concern is the vagueness of cause alarm to somebody. It reminds me of the old, with the disturbing the peace, the peace of the police can't be disturbed. So someone has to actually complain. Otherwise, and what does cause alarm mean? There's a lot of concern about that particular phrase being constitutionally vague or not. Do you have anything to add to that? And if also, what was the impetus for bringing this?
Yeah, so this stemmed from the Department of Safety had a meeting with child care agencies because what was happening is one specific agency in particular in Claremont was experiencing a sexual offender that has offended kids under 13, because that's what this bill is towards, is those that are only have offended kids under the age of 13, sitting outside on a public bench outside their playground while the kids are out playing, to the point that they're not comfortable and now they want to take the kids inside because they don't feel comfortable leaving the kids with the sexual offender sitting outside watching the kids on the playground. So I think that's a little bit where the alarm comes in. I think if you could even remove alarm and just leave it as legitimate purpose and not necessarily have to cause alarm, but just not be in that area sitting on a bench. You can go sit on a bench somewhere else, but for the mere fact that they're sitting on a bench watching children when they've offended a child under the age of 13 is where the cause for concern comes into play.
Thank you. Questions? Representative Mears.
What are the legitimate purposes that you're defining in the amendment?
So when it came, when I was given this, we looked at the presence of a parent or legal guardian or employee contracted service provided for child care, school or facility, because there is sexual offenders that do have individuals that are in child cares or in schools that do have a right to be at their children's events as long as they have a child there, or in under a court order or participation in a supervised program. Presence at officially authorized meetings, events, or services provided the person registers in advance with the facility or school and provides any required supervision. So it's main points that they should be in the school or be at a child care facility.
Would you consider voting at a school or attending a town meeting that might be taking place at a school a legitimate purpose as well?
I would.
Thank you.
What about, to your example, sitting on a public park bench? I mean, how is that not legitimate?
I think when it comes to someone that's offended children under 13, I think it's where it's placed. So it's within that 1,000 feet of that daycare center or school that they're watching children and they don't have a child that's in that daycare center. And that's when it becomes not a legitimate purpose. If you want to go sit on a bench somewhere else that you're not watching kids just due to the offense they have committed.
Thank you. With the 1,000 feet, that just reminded me of something back in the day when I used to be involved in this. One time we put a map of the city up, and it used to be the drug law, and you can't be selling drugs within 1,000 feet of a school or a playground. When we drew the circles, there was nowhere in the town that you could sell drugs. 1,000 feet is an extremely long distance. Has anyone considered why that far?
I think that was just the standard
Okay.
that was put out there.
Okay. Thank you. Representative Scheer.
Two questions. First, following up on what the chair asked you. I'm from Portsmouth. Middle school is right downtown. 1,000 feet in from around the middle school would encompass the entire downtown area of Portsmouth. There's a number of and there's 3 elementary schools and any number of daycare facilities. And I think in real terms in Portsmouth, 1,000 feet around any school or child care facility would encompass the huge majority of the town. So, you know, how would you feel about it being 100 feet instead of 1,000 feet?
I think that would be okay. I think it's just to encompass those certain times. It's not to say you can't go have dinner somewhere that's near a daycare center. You know, it's not trying to limit where they can go. It's just limiting where they're near children.
I've seen a draft of an amendment, and that's been very helpful. And thinking, my guess is you probably have some version of that also. The way it's written, it feels like the legitimate purpose is narrowly defined. So unless you meet one of those 3 criteria, you don't. There would be a finding you don't have a legitimate purpose, and that language is. Is there another way to use it, to come up with language rather than legitimate purpose, as it's so narrowly defined? Because, you know, somebody's just walking through town. I'm not sure. The way it's written, they need to have some specific purpose. Otherwise, it's not a legitimate purpose.
Well, I think if they knowingly enter and remain there is how it's described at the top. So if they're knowingly entering and remaining there, walking by something is not remaining in an area for an extended
No,
period
but
of
what
time.
about legitimate purpose? His question is,
Right, I understand. So I would have to,
in other words,
see if there's any
there
other
could be
way
a
to-
million legitimate purposes and you
Right.
can't codify them all. So language, something like perhaps that a reasonable person would consider legitimate purpose type of thing, maybe.
If I may.
I think that's part of the struggle.
You're next.
Last question. Other than what you heard from up in Claremont, have you heard of specific problems in other areas of the state with other childcare facilities, with schools?
I have not personally, Sergeant Peralta is here from the sex offender registry along with the child care agency that might have more examples.
Thank you.
Representative Prue.
So, in my understanding, if you're walking, you don't need a legitimate purpose. But if you stop and gawk, you need a legitimate purpose.
Correct.
And I'll take your 100 feet and I'll raise you 150 to 250.
I'll say, wow, we're going to go about defining gawk.
Gawk's in the dictionary, but we'll get to that after. Any further questions? Seeing none, thank you.
Thank you.
I was trying to be nice with gawk.
The chair calls Molly Tremblay.
Good morning, everybody. I'm Molly Tremblay. I am a child care center director in Claremont. And this is a real problem. So one of the things that I was thinking about last night is people drop their children off to be in a safe place. People drop off their children to us and expect them to be safe and be cared for, loved, and be able to have a safe childhood experience. With these offenders being able to just freely roam and stare and gawk at our children, it's not a safe choice. It's a safe option. It's proving to be a hindrance to my clientele who don't want to send their child to a childcare center. They would rather send their child somewhere else, to a home daycare or a at home with a sibling, because they feel that we're being targeted with these offenders who will seek out and have offended before, so they're known people, and they don't want them in our care because they fear they're not going to be safe. As I heard earlier, there was a question about if this has happened in other places other than Claremont. I have spoken with other directors. We have a network together, and they are in the same boat as us. It's not just Claremont. There are other places that this is happening. It just so happens that Claremont is where I come from, and I was the one available. So I just really hope you guys consider this bill and consider the safety of these children who are in our care, and they need to be in our care and have a safe, supportive environment.
Thank you. How many times has this happened at your particular facility?
In the last year, I'd say we've legitimately called the police about 5 times since this would be since about October of last year. There have been times where we've kind of turned a blind eye a little bit and said, okay, they're there, we see them. And sometimes they will move along, but when it becomes prolonged, that's when we actually call the police and they will come and deal with it.
Has this been one individual or different individuals?
No, there are multiple individuals.
And are there police reports of these incidents that you're aware of?
I would say they'd be in the dispatch records.
Yeah.
We have not had a specific police report for our center.
Yeah.
But we also have a very good relationship with our police department, and they will come at the drop of a hat pretty much for us because we had other conversations with them and have a good relationship with them.
And what was their response?
So they'll come and they'll tell them to move along, but they are so busy with other things that sometimes they forget to follow up. So this person will be moved along, but it could be 20 minutes later and they come back. Sometimes, like I said, we turn a blind eye sometimes because we're inside at that point, or we're, keeping an eye out as a teacher. But we have recently, they've been starting to come and do a drive around afterwards, and just make sure that they're gone. And sometimes it turns out to be a little bit of a butting heads with the police department and the person, and they're like, "Come on, man, I'm not doing anything," but they try to urge them along as best they can. But because there is nothing there saying they're not doing anything wrong, there's no leg to stand on. They can't really force them to move along.
Thank you. Hold on. Representative Scheer had his hand up first, I believe. You're good? All right. Representative Lassell.
Yes, thank you for taking my question. And thank you for being committed to the safety of the children who are in your center. The first sentence says the bill prohibits certain registered offenders. I'm just wondering, are there different categories of registered offenders?
I believe.
Hold on a second. You don't have to answer that because you're not an expert in that field, are you? But we'll get someone else to tell us about the different levels. It's a complicated thing. I think someone else is going to testify.
Thank you.
Yeah.
Sure.
Any further questions? See none. Thank you for coming. Oh, I'm sorry. Excuse me. Representative Muse has a question.
I'm curious about your interactions with police, because it seems like it seems like we already have loitering statutes on the books, and we're actually seeking to modify a law that we already have. What is it in our current law that isn't allowing police to take action? Why do they think that all they can do is move people along?
I'm not the expert in that. I'm not a lawyer. I'm a childcare director. But most of the time, it's because they're not actually on our property. They're just within this certain. So our center is on one side of the street, and then there's an empty Rite Aid building on the other side of the street. And they will sit on that Rite Aid property and sit right there and just kind of stare. And our playground's out front, so they will sit and stare. So it's not technically we've been told it's not technically our property, so it's not technically our job to trespass them or loiter them. It's the Rite Aid. But unfortunately, there's nobody at the Rite Aid, so it's kind of stuck between a rock and a hard place. But again, I'm not an expert on
No, that's
that,
okay.
so.
That's good enough. Thank you. Any other questions, Representative Muse? All set? Okay. Seeing no further questions, thank you for coming in today. I know it's a drive.
Thank you.
Who's next? Chair calls Jackie Cowell.
Good morning. How do you do? I'm Jackie Cowell. Good to see you again. I'm here from Early Learning New Hampshire. We're a statewide nonprofit, and we work with childcare providers. And and good morning. And this bill, as I think you might we mentioned before, came from we hold with some partners 2 times a month a Zoom call with the childcare community. And we have about 100 people who show up in real time, and then it's recorded, and then people watch the recording, etc. And this thought of this idea, as we were talking about priorities, came up during those calls. It included the folks from Ready, Set, Grow, but there were other providers who had some concerns, had some problems with folks that were sort of feeling menacing, and they had called the police, and they did go away, but they then came back. And childcare programs are very, very differently configured. Again, it can be a home, it can be somebody's home. It can be a program right on the sidewalk, right next to the sidewalk. Linda mentioned last time Molly mentioned last time she was here, they ended up frosting the windows of the toddler program because it was scary. Both for the staff, and they were worried about pictures being taken. They were worried about, what's going on, are they watching, etc. So that's why we went to the New Hampshire Department of Safety, and they, listened to us, a few others, and we're at the table of the childcare community, and that's how this was written. And I do appreciate understanding that it was too broad. That's not our expertise. We're just trying to find a way that they don't have to just be constantly back and forth and back and forth and back and forth. And like you heard, sometimes they would just kind of give up, but still be scared or still worry about the kids. So that's why this came forward. And we look forward to finding a way that makes it reasonable and understandable, not hurting anyone's rights, but at the same time, not having that kind of thing keep happening. Yeah.
Thank you very much. If you're aware about how many other incidents or places around the state has this happened?
Yeah. We didn't ask folks specifically if they'd had the incident or how many times. What we did ask them that, does this seem like a good idea? And some people said, yes, it had happened. And some people said, I don't want it to happen. They didn't use the word deterrent, but, something that maybe it would just stop them from even trying if there was something clear that, that was the conversation. Yeah.
Representative Scheer.
Thank you, Mr. Chair, and thank you for testimony. I think you appreciate that we're trying to figure this out.
Yeah.
And it's hard to write language that gets to what we want to get to without having it be way too broad. And I just want you to know and let people know that we understand the problem, and we're really struggling with ways to make it work.
Thank you. Appreciate that.
Would you believe that?
I believe it.
Yeah. Good. Further questions? Seeing none, thank you for coming in today.
Thank you.
The chair calls Gilles Bissonnette.
Thank you, Mr. Chairman. Chairman Roy, it's good to see you. It's been a while. This is my first time appearing at the legislature this session, so it's good to be back and to see everyone. I'm with the ACLU of New Hampshire. I'm an attorney there. We're here in opposition to the bill. I'm going to talk principally about the bill just as drafted. I understand that an amendment could be proposed. I could probably talk a little bit about that, though I don't obviously know all of those details, but I'm principally going to just
Well,
address them.
it's safe to say that the bill as written
Yep.
is not going to, so if you
Understood.
we would be interested in hearing helpful thoughts.
Sure, sure. Understood. Just a few kind of broad points, some of which are germane just to this bill, but some of which will also apply to both. First, at least as written, and this came out a little bit before this committee during the prior House bill, it is unclear to us whether as written this language would be necessary because loitering is already an offense. This would just create another version of loitering that's subsumed within that. So I would just convey that position to the committee that I know the committee is already well aware of. There are multiple layers of vagueness with respect to this bill. I also think there could potentially be layers of vagueness to even a new iteration that I want to walk the committee through. There are some cases that we cite in footnotes that could be informative as the committee is considering next steps. But with respect to the loitering version of this bill that's before the committee, we continue to have concerns with the language, in particular, under circumstances that would warrant alarm, which exists not only in this bill, but in the underlying loitering law. I would just, to be brutally candid to the committee, that law is under challenge. My office is involved in that challenge, arguing that those provisions are vague and thus violate due process. So I just wanted to inform the committee of that. I'm happy to get into the weeds of that, but I just wanted to make sure the committee knew. Sure, understood. I do think there are other layers of vagueness that both to this existing bill and potentially even to any new amendment that I just want to walk the committee through. The first is ambiguity with respect to the phrase within 100 feet of any of the following places: childcare facility, church, though it sounds like churches might be omitted. It sounds like any area where a reasonable person would know the minor could congregate might also be admitted. That's good, and I would encourage the committee to omit those. But there could be additional ambiguities with respect to boundary lines. Like, how do you define that? Is it the structure? Is it the property line? It's pretty fraught, frankly, how you define that line. This bill doesn't define that line. I don't know if any amendment would define that line, but I just want to flag that. Like, the lines really matter, and there has to be significant precision. And I'm going to be honest, it's hard to do in as you're articulating boundaries. And this came up on page 2, footnote 3. This came up out of a piece of litigation out of Rhode Island. They just want to make the committee aware of with respect to boundary lines. I think at a high level, setting aside vagueness concerns, just want to articulate just some high level concerns we have with the concept. Listen, if we're dealing with sex offenders or anyone for that matter on private property, whether it's the property of a child care facility, whether it's adjacent private property, you can regulate that through trespass laws, already existing laws that allow individuals to be removed who don't have permission of the property owners to be there. And I think why that matters is because the underlying concern, at least that we have at its core with legislation like this, is you're just regulating the ability of people to be in public places, which we have a right to be. Park bench, park, sidewalk, traditional public fora for expression, those types of places. And so that really, I think, is one of the underlying concerns that we really have. And when you talk about the ability of an individual to be in a public place, to travel through public places, to use public places for expression, we just have to be incredibly careful. And I think high constitutional standards of scrutiny traditionally apply to those types of regulations. That would apply as well to any amendment. And we've most recently seen litigation on that front. I don't want to say recently, but we've seen a lot of litigation nationally on that front in the context of sex offender residency restrictions. We haven't seen in New Hampshire a state law on sex offender residency restrictions, but we have seen municipal ordinances. And the courts, both in Franklin and Dover, have actually struck those down. And so we actually have some New Hampshire Superior Court decisions, not Supreme Court decisions.
If I may, were they struck down on the basis of they didn't have the authority to make those rules, or because they found them unconstitutional?
They did. They found them unconstitutional on equal protection grounds on Part 1, Article 12. And in fact, I've circulated those decisions, though there was a lack of authority argument raised in those cases as well. And so I do think that's informative for the committee, just so the committee just understands like what the layer of scrutiny would be here. And I think it would be a form of intermediate scrutiny. And I'm not suggesting that there isn't a compelling justification for a bill like this, but there's always necessarily a tailoring concern, because when you regulate the ability of someone to be in a public place based on a couple isolated instances, assuming they were even sex offenders, tier 3 sex offenders, which I don't know, maybe they were, maybe they weren't, you know, you're casting up a pretty broad net, right? Because we're dealing with the ability of people to be in public places. And I do want to echo 1,000 feet, like, is a lot. Okay. My community of Concord, for example, there's a park 600 feet from the Krista McCullough School. And so someone would be precluded from using that park under this. So I do think, you know, there are some just underlying legal concerns with this would apply presumably to any amendment, with just regulating the ability of people to be in those types of public places. And I think a court would look really carefully at, is this really tailored? And we have 2 Superior Court decisions in the context of residency restrictions that I think would be informative to the committee's thinking. I just want to go through my notes to make sure I'm not missing anything. So in that sense, I think an amendment here probably trades one constitutional problem for another. I think it certainly would make it less vague, right? Because you're eliminating the loitering standard, though there could be still vagueness around boundaries. But setting that aside, you'd be replacing a vagueness issue with a potential equal protection issue. Again, that all really, I think, depends too on how legitimate purpose would be defined. I'm not entirely sure kind of what that definition would look like. That would be critical to any court's analysis in evaluating whether an amendment would be constitutional. And just kind of the final point that I want to make, and I'm not here, and I don't want to diminish the real concern, being scared. I get that. I understand it. My child went to NHTI for daycare. You know, I'm a parent myself. I understand that it's a real concern. You know, I'm just here to say this is really fraught. I'm not sure if you can do this constitutionally, but it has to be done, if at all, with real care. I do think just when we start regulating based on discomfort, you know, that could this create some concerns. People can be uncomfortable for a lot of things, and I'm always hesitant to do that, particularly when we're talking about people just occupying public places. So I think with all of that, I would urge the committee to vote this ITL. I obviously understand the committee might consider amendment. I'm happy to provide feedback on the amendment, but I think for all those reasons, we continue to have concerns with this type of legislation.
Thank you. So a lot of things. I mean, we got to be careful we don't get into a constitutional clause.
Sure.
So it's long held that if someone commits a certain offense, they themselves surrender some of their constitutional rights. Mm-hmm. For example, firearms. You commit a felony, you can't have firearms anymore. Yeah. You commit a sex offense, there are legitimate limitations that can be put on a person. And I wonder if we're not looking at it the wrong way. This geography thing is what gets really, as you said, fraught with problems. Instead of the geography, just on the person themselves who's offended. In other words, you cannot go within 100 feet of a place where children are, that type of thing. Have you seen other states, because I know you're active in every state in the country, where a successful law has been put in place that met constitutional scrutiny and still protected children? Because the committee's aware that this doesn't happen in a vacuum. I mean, there's legitimate chat places online where these sex offenders go, and they actually share information about places where they can go see children. It's frightening. It's horrific. And if we take that, if we don't take all that into account, something bad will happen. What are your thoughts? on
Yeah, no, so I think a few thoughts, and I'm not going to pretend like there's unanimity among the courts here, and I'm not representing that to the committee. What I am representing though is we have two Superior Court judges in New Hampshire that have adjudicated, not completely in this context again, but just in the residency context, have used a form of analysis that I think would equally apply here, where there's a heightened form of scrutiny, and I do think. Again, not to belittle the concern. It's a real concern. As a parent, I'm concerned. It does seem to me though, maybe it's not perfect, but it does get us there significantly. The fact that we just have existing laws on the books with respect to no trespass, that it seems like in most of these cases, and I'm not going to represent all based on the prior testimony, that police do show up, that police are responsive, that in most instances, police are able to move along those individuals. And so it's not entirely clear to me that even if this passes, that it may even necessarily accomplish the objectives, because you would still need a phone call to be made. You would still need a police officer to show up, all of those things that exist now under the current legal regime. So I think that's just my response, because this is pretty sweeping under the current bill. It probably would be, or may still be sweeping under any amendment. And it's just, of concern, at least to me, when again we're just regulating the ability of people to be in public places.
Representative Scher.
Thank you for your testimony. Looking at the conduct that's in the proposed bill as it exists now, and looking at the existing 644-6, what's your opinion as to whether the conduct captured in the proposed legislation, amendment to 644-6, already fits in 644-6, putting aside the vagueness issue?
Yeah, I think it already does, and that might be why people have been moved along, to some extent already. I think, yes, exactly. I mean, the way this is currently drafted, it's just kind of subsumed within. So if one were to use the loitering rubric as a way to address this, I'm not sure you would even need this, because the loitering rubric, setting aside potential vagueness, would already cover this. It would address sex offenders. It would address anyone that might be behaving in a way that would warrant alarm.
Follow-up? I looked at the language of the sexual offender registry, and one of the things that happens is when somebody who is in one of the three tiers moves to a town, that the police department is informed, and the school,
That's true.
the head of the schools department is informed. What if childcare providers were also informed? Would that make it easier to apply the existing loitering statute?
Yeah, I mean, I wouldn't see any constitutional objection to that. Just informing. I mean, the public is already informed in a more broad way, right, with respect to the sex offender registry, but just more direct notice by law enforcement that there are registrants in particular locations, setting aside the potential stigmatization of that. There's nothing, I think, that would constitutionally prohibit that. Law enforcement have that information. It's public information. Law enforcement can disseminate it how they see fit in order to promote public safety.
One more follow-up. My understanding is you've seen a potential amendment to this legislation. Is that fair to say?
Yeah, I've seen a version of it. Yes, the legitimate purpose
Exactly.
piece. Yeah.
Could you delve a little more deeply into your concerns about the breadth or narrowness of the definitions
Yeah.
of legitimate purpose?
I think there's a couple issues, and again, this kind of goes back to my prior testimony that you might be trading one issue for another, a vagueness issue for an equal protection issue. I think that the two concerns that emanate from that are, one, continue to be the issue with the 1,000 feet, the scope of that, and I think number two, just again the fact there that you would still be regulating the ability of people to be in public places. The definition of legitimate purpose would really be critical. And under the definitions that I've seen, at least that I saw yesterday, it seemed pretty narrow. The definition of legitimate purpose seemed really narrow, and maybe even could preclude people just walking along a sidewalk within 1,000 feet, having dinner at a restaurant within 1,000 feet, potentially residing within 1,000 feet. So this gets back to the kind of point I'm making before. If the committee's trying to sort out how do we define legitimate purpose, that it very challenging. I don't know how to do it. I don't know how I would do it. So I would just highlight that concern.
Thank you.
I just, I'm concerned that we just had a bill recently that would have imposed the death penalty for a sex offender or a child under 13. So as a society, on one hand, we're balancing people are suggesting putting them to death or at the minimum, keeping them in jail for life versus allowing them to go free after their sentence. If we don't find a way to make that, it's going to start going back towards the longer prison sentences. So we have to, it'd be in everyone's interest to find a way to do this constitutionally, where as a society, our only response is going to be longer incarceration periods to protect children. So I want to find a...
Yeah. No, I understand. Oh, I'm sorry. I didn't mean to interrupt you.
No, go ahead.
I think my only response to that is, one of the things this bill does cover, right, would be individuals who've committed these offenses but have otherwise served every part of their sentence, right? And so that I just want to highlight that dynamic as well. We're not necessarily here talking about parolees, which could I'm not, and in that context, there actually could be potentially even conditions imposed. So I just wanted to highlight that fact. So.
Yeah, go ahead. I'm sorry, Representative.
Yeah, so I'm just wondering, does it help if suppose you take out the language either about like legitimate purpose or under circumstances warranting alarm, but suppose that you otherwise made the bill much narrower in other ways. So that, for example, suppose you said that in order to violate it, that it would have to knowingly remain within, and suppose you cut down the distance to like really short, like 25 feet or 50 feet, knowingly remains for an extended period within 25 feet of any of the following places, and then you limited it to any school or daycare center attended by children under age 10 when it is in session or when it is open or something like that. In other words, basically you're saying that if you are convicted of these offenses, you can't hang around, so to speak, these places with a pretty narrow definition of what that means and what kinds of places it applies to. And I mean, I would assume that if you had it, if you limited it to pretty young children, that there would be a much stronger argument that they're unable to, they are particularly vulnerable, that kind of thing. Does that help?
Yeah, I mean, I'm not going to dispute that narrowing it would at least mitigate some of the constitutional concerns. And I think those would certainly be ways to consider it. Do they eliminate all of them? Does it completely foreclose a claim? I don't necessarily think it would, again, given that we're dealing with public places. But, Justice Lynn, I'm not going to pretend that efforts to narrow this, wouldn't, at least get us part of the way. I continue to think that even if you were to create, even under those narrow circumstances, categorical provisions, that we still want to also be mindful that we don't want to preclude people from, again, maybe if the number of feet is small, this wouldn't be an issue, but just like walking down the street on a sidewalk adjacent to those areas. This gets back to the point I was making before about legitimate purpose and how you define it is still going to be tricky, even with those narrowing limitations, though those limitations obviously would make the bill better. I don't know if it addresses all of the constitutional concerns.
No, thank you.
Representative Lassell.
Thank you for taking my question.
Thank you, Representative.
We've mentioned the loitering statute several times. Can you tell me how many times there have been successful prosecutions of the loitering statute in New Hampshire in the year?
Sir, before we filed the lawsuit, we actually did a statewide investigation for about 2 years to try to figure out how this law is used. I just thought that was a prudent thing to do. If you're thinking about challenging a law that's been on the books for decades, you should have an idea, is it really a problem in practice? We don't litigate law school exam problems. We litigate real problems. I know. And under our investigation, based on data that we received, it seemed that there were around 200 cases in a given year in which the loitering charge was used. That doesn't mean it was the only charge in an individual case. It could be a charge stacked with other offenses, but sometimes it was the only charge. And so it was that data, among others, that caused us to want to bring the lawsuit because of our concerns about the law.
200 over what period of time, and how many of those were successfully prosecuted?
Sure, 200 on average per year. We collected data from approximately 2002 to 2025, and that number was actually relatively consistent during that 2 to 3 year phrase. Now, that's filed charges. How many are successful? I don't have that data. I'd have to pull all the case summaries. Many are successful where people plead out to the offense. Sometimes the charge is null prost. In fact, that does often happen where it might be a charge added to multiple other charges, and maybe the prosecutor decides at some point, I don't really need the loitering charge. But again, the loitering charge often, it can be a charge on its own. It is a violation level offense, which means unless it's being coupled with a Class A misdemeanor charge or a felony charge, you may not even have counsel to court-appointed counsel if you're indigent. I hope that answers your question, Representative. But I don't have the exact details on stats to get that granular. But many were successful. Many people pled guilty. Often it was dismissed. There's many ways in which those charges have been disposed of.
2 questions. So you just mentioned it was a violation level offense.
Sir.
So being that the police can't arrest somebody for that on the first instance, is that correct?
Oh, no, there is authority to arrest. You can actually arrest for a
on the
violation
first
level.
instance.
Yeah, and that has happened. I can represent that.
And the second one is the 200 cases average a year. Are those mostly in Manchester and Nashua? Are they city-based offenses, or is it really spread out across?
It is pretty spread out. I would say a majority, are in cities. It may even be a vast majority, but no, it is, it percolates in every circuit court to various degrees. I was kind of surprised by that fact too, actually, when we did our study. I thought I'm just going to see cases out of Concord, Nashua, and Manchester, and that wasn't the case.
Share.
Thank you. And just thinking about alternatives, undetermined section of people who are tier 2 or tier 3 sexual offenders are, when they're released, are on either probation or parole. Is that right? Mm-hmm. Fair to say those convicted of sexual offenses, their maximum sentence, which determines how long they're on parole, for example, is often 20 or 30 years.
Yes.
What is the constitutionality of having a statute that requires a provision of parole for those people to be a condition of not remain, using the language that Representative Lynn used about being around schools, childcare. You have any sense of that?
Yeah, I would need to think a little bit more about it. Listen, the standard for parolees is going to be far more deferential to the state. So I
You
want
don't have to think too far. I'm gonna create a subcommittee on this. So.
Oh, okay. I'm sorry.
Yeah, no, I
I'm
just wanted
sorry.
to save you the trouble.
But I also,
We
you
have
know,
until May. So
there has been some litigation on, conditions, that are imposed on sex offenders, even just, even as punishment, as part of their sentence when they're out. So I can't admit that it would be fully constitutional, though the standard is different, might be more deferential to the state than the standard that would be applied here to, say, a person in a public place that may have served all the conditions of their confinement, but that's just on the registry.
Thank you.
Thank you. Thank you very much.
anyone else wishing to testify on this bill who hasn't done so? Seeing none, I close the public hearing. I will notify you on this subcommittee at the end of the day or tonight sometime. What's next? I open the. Yeah.
So the chair knows, I'm not going to be here at the end of the day. I have to leave after the 12:30 hearing, but
It'll be an email that
yeah,
goes
and
out
I'm more than
tonight.
willing to be on the subcommittee.
Thank you. Let me see. What do we get? The hemp, 461. Open the the public hearing on Senate Bill 461, and invite the sponsor to just whatever. Either way.
All right. Well, thank you, folks, for having me. For the record, I am Senator Donovan Fenton, and I represent District 10. And I'm here to introduce Senate Bill 461, a bill that makes one simple but important change to our hemp law. 461 clarifies that the total THC concentration includes not just the Delta 9 THC, but the sum of all THC variants, including, and be gentle with me as I pronounce this, tetrahydrocannabinolic acid. So we're going to call that THCA, all right? This brings New Hampshire's law into alignment with recent federal changes that are scheduled to take effect later this year. This matter is important because right now some New Hampshire retailers are selling unregulated, high THC cannabis products labeled as THCA flower and THCA concentrates under the guise of being federally legal hemp. Since THCA converts to THC when heated, these products are functionally the same as marijuana, but without any of the rules, testing, age restrictions, or consumer protections as we would expect. Mr. Chairman, you probably know I'm a supporter of legalizing and regulating cannabis for adults over 21 years old, but I believe strongly that we need to do it the right way. That means safer, responsible legalization with stronger guardrails that protect public health and safety. Regardless of where you stand, I hope we can all agree on this. High THC products should not be sold in New Hampshire with zero regulation. If we're going to legalize cannabis, and some may agree we should, or some may agree we shouldn't, but we have to do it a responsible way and with a strong regulatory framework that keeps products tested, labeled, and out of the hands of kids. Until then, we should not allow a loophole that creates a wild west of cannabis market with no rules at all. This is a very simple, necessary fix that closes an obvious loophole and supports a safer, more responsible path. Thank you, and I'm happy to take any questions.
Thank you, Senator. First of all, I tried to reschedule and I missed the calendar.
I won't take it personally.
No,
It's all right.
And but if you just want to have someone introduced this afternoon, you don't.
No, I'm fine. I like to introduce them, okay. So I'm happy to, but I appreciate that, Mr. Chairman.
I tried. With that, any questions for the Senator on this bill?
Real quick, I'm sure you have questions about what the products look like.
Yeah.
The next speaker up is going to talk about what the products look like and kind of show you some examples of them as well.
It's my understanding these are also available online. Would this bill in any way make it illegal for someone to get these that way?
Good question. I don't have the answer to that, but maybe the next speaker can answer that.
Okay.
Yeah.
Thank you. See no further questions. Thank you.
Thank you, guys.
Chair calls Matt Simon.
Okay, good afternoon, Mr. Chairman, Honorable Committee. For the record, Matt Simon, Granite Leaf Cannabis. Good to see you all again. I do support SB 461. I believe this is the first time a hemp bill has come to this committee, so I'm going to try to explain at a very high level in 3 minutes, and then I'll let you ask me questions. So I've been following this very closely for many years, and especially since 2018, when hemp did become federally legal. First of all, the terms hemp and marijuana both refer to the same plant. It's cannabis sativa. The only difference is the THC level. Hemp is defined under federal and New Hampshire law as containing not more than 0.3% Delta-9 THC. These laws were passed based on the understanding that hemp products would be non-intoxicating, containing only trace amounts of THC. That is not at all how things have played out in practice. So people expected that the federal government would step up to regulate CBD and other cannabinoids. They still haven't done that 8 years later. So the company started doing things that were not what people expected or intended. We talk about a loophole, it's actually 3 loopholes. The first loophole was what we call the Delta-8 loophole. Hemp companies would grow fields of hemp, harvest the CBD, and then chemically convert it to Delta-8 THC or another form of THC. And in 2023, New Hampshire, we closed that loophole by adding language to the hemp law that you can see under 2023 here. But there are 2 other loopholes that we haven't closed. So one is the edibles loophole, because 0.3% is a percentage. If you make a product bulky enough, you can put lots of THC in it. So whereas adult use, quote unquote, marijuana laws usually limit THC to 5 milligrams or 10 milligrams per serving, it is very common to see hemp edibles that are 100 milligrams, 500 milligrams, or even 1,000 milligrams of THC hemp edibles. Extremely intoxicating. And those are technically legal because they're less than 0.3% by dry weight. The third loophole is what I call the THCA loophole, sorry. And it's the most ridiculous one of all because THCA flower is essentially marijuana. Hemp companies are growing high THC cannabis, and they're making high THC products out of cannabis, and they're calling it THCA because THCA is non-intoxicating until you heat it up. So if somebody's growing cannabis legally or illegally, it's mostly going to be THCA until you decarboxylate the THCA by either heating it or cooking it into an edible. This is why picking raw cannabis off a plant and eating it doesn't get you high. Making brownies out of it, eating them does. THCA converts to Delta-9 THC. So in November, Congress made an effort to correct their previous error. They redefined hemp under federal law, did several things, some of which are controversial. What this bill does is the least controversial of the things. So I've run this by licensed hemp farmers in New Hampshire. They don't like the federal definition overall. They're okay with what this bill does, which is basically says THCA is THC, and we're going to define hemp by total THC being less than 0.3%. So there is another bill as well. It's SB 624. It's passed the Senate. It does what this bill does. It also does a bunch of other things, and it's in another committee. So I just want to let you know it exists. As far as this bill, it is trying to make one change that mirrors the aspect of the federal definition that has been least problematic. So I've got another handout that illustrates some of the products. And I've got one in my hand here that I bought in North Carolina over the holidays. So this was manufactured in California. It says THCA live rosin vape. So you can see it's a vape, just like a lot of other vapes. I bought it at a hemp dispensary. Cannabis isn't legal in North Carolina. It's not even decriminalized. They don't have a medical program. They don't have any legal access, but they have dispensaries everywhere selling THCA flower, THCA vapes, THCA concentrates, THC edibles, all under the guise of federally legal hemp, completely unregulated. So these photos in this handout are all from a store, from a company that operates in New Hampshire. They have a few locations in New Hampshire. I'm not picking on this particular company. It's just a very easy example because they have everything on their website and they have stores in New Hampshire. And they're very transparent about the fact that these are high THC potent products. The big difference is in a regulated cannabis store, we report total THC. If you look at our labels, we will add THC and Delta 9 because that's what a consumer needs to know. How much actual THC is in this after I smoke it or vape it or eat it. Hemp companies don't do that. They say, we're only going to report Delta 9 THC. It's going to be under 0.3%. And we can have 99% THCA. And we're going to tell you it's a federally legal hemp product. So this starts with flower. Snow caps are flower coated in THCA isolate, 54% THCA. THC hash, they say, is 69% THC. THC diamonds, 99% THCA. And they make no effort to hide that these are potent products. So this product, the vape that I bought, has a slogan on the side. It says, potent as four-letter word beginning in F. So these are intoxicating products, and we should not allow them to be sold in New Hampshire without any form of regulation. And I would be happy to answer any questions.
Thank you. So as the feds have already changed it, is this necessary still? I mean, if they're federally illegal based on the new definition, why do we need to do it as well?
Good question, Mr. Chairman. So the question is somewhat enforcement. And if it's only legal federally and not under state law, no state agency would have the authority to do anything about a New Hampshire retailer that's selling these products. They are available online, mail order currently. Presumably that will change, assuming the federal change takes effect and assuming that somebody enforces it. But currently there's no enforcement authority. So the liquor enforcement can enforce against entities that are licensed by them, but some of these stores don't sell tobacco or alcohol. They're standalone CBD stores, and who regulates them? Currently nobody. So that's making it clearly illegal under New Hampshire law would mirror the federal definition. It would give clarity to New Hampshire businesses, what's legal and what isn't. This company and others will have information on their websites saying these products are legal in these states and not in these states. And New Hampshire is currently listed as one of the states where they're legal. So they would no longer be able to do that if we clarified our law. Okay. One could argue we should do more and do the enforcement stuff that's in the other bill, but I'll leave that conversation for the other bill. This is a clarification of a definition that I really think we should pass. 624, SB 624 is referred to environment and ag.
And it's enforcement, but it's in ag?
It includes what this bill does. It also changes other aspects of the definition. It takes on the edibles loophole. There will be more controversy around that bill based on what I've heard. I would expect some opposition testimony on that one. We'll see how that conversation goes. I don't know whether that one will pass or not, but I feel strongly about the definition being clarified, you know.
Okay. Further questions?
Yes.
Representative Charbonneau.
Thank you, Mr. Chair. Thank you for taking my question. So this bill defines the hemp as being at 0.3% on the dry weight basis. Is there a separate standard from what I hear as a product that is considered, quote, industrial hemp, or am I misinformed?
Industrial hemp and hemp there's no difference legally between those terms. The whole concept of hemp is that it's not a drug, that it's, if you read 439A, the hemp statute, it lays out a list of things that hemp products were supposed to be: cloth, cordage, food, blah, 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 nothing about inhalable psychoactive substances.
Seeing no further questions, thank you.
I'm sorry, Mr. Chair, if I may, one last thing that the senator was going to mention and I forgot. There is one word that should be struck from this bill. It was an error for the word Delta 9 in line 4 to be there. So the effort is to make it with a tetrahydrocannabinol concentration, scrapping Delta 9. So it could be Delta 8, Delta 10, whatever it is, total THC, but the word Delta 9 should be struck from line 4 to make this do what you want.
Would you get a exact language suggestion, please, and send it to the committee so that we can look at getting an amendment for that?
Certainly.
Thank you. Any further questions? Seeing none, thank you for your testimony. And
Thank
yeah, send us, if you could send it to the clerk and we will get it. The chair calls Jake Berry.
Good morning, Mr. Chairman, honorable members. My name is Jake Berry. I'm the Senior Vice President at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We've been working for nearly 30 years to help address drug and alcohol use across our state. I don't want to repeat too much of what's been said here this afternoon, but I do want to emphasize our strong support for this bill. This bill is basic consumer protection. It doesn't ban any particular products, as you've heard. It just ensures that that the companies disclose and that consumers are aware of exactly what is in these products that they are consuming. We've done this for alcohol forever, and it's just as important that we do so with these highly potent products, which in many cases are produced in a way that it can be appealing toward youth users especially. So it's really important that we get this right, that we make sure that we know what's in the products on our shelves and that we then know that the impact that they can have. I've distributed written testimony that details some of the rest of our support for this, as well as testimony from a colleague of ours, Dr. Cynthia Whitaker, who's a clinical psychologist out of Bow, who gets a little bit more about the impact that these can have, instituting instances of psychosis and so on and so forth. But needless to say, we're strongly supportive of this bill. We hope you'll pass it. I'm happy to take questions.
Any questions? Seeing none, thank you for your testimony. Anyone else? Anyone else wishing to testify on this bill who hasn't signed up to do so? Seeing none, I close the public hearing. I open the public hearing on Senate Bill 521.
Good afternoon, Mr. Chair and members of the House Criminal Justice Committee. My name is Tara Reardon. I'm a senator representing District 15, which is Concord, Bow, and Hopkinton. I'm the sponsor of Senate Bill 521 relative to unauthorized camping on private property. This was brought to me by one constituent and then a second constituent that piled on afterwards. And current law prohibits camping on public property or public right-of-way, but there's no parallel provision for private property. The bill as written is for cities and towns with a population of over 10,000 people. This would apply to 11 cities and 18 towns in the state of New Hampshire. And we really did that because homeless occupation of private property is not only a real problem here in Concord, but most other larger cities and towns are experiencing it also. The logical solution for somebody who has somebody unauthorized camping on their property is to do a no trespass order, but no trespass orders take time. And we did have testimony that you have to identify that somebody's there, you have to go to the local police, you have to get a written order, and then have that order served. And in the case of one of my constituents, that took about 10 days, even with posted no trespassing signs on the property. And the 10 days to serve the order resulted in $50,000 of cleanup that was required on the property because of hazardous waste that was there. It was quite a little homeless encampment, and it was not only drug paraphernalia, but human waste and things like that. So $50,000 to that constituent. The other constituent story that I'll share with you was a private residence with some trees behind it. The family swing sat right there at those trees. And beyond those trees a little bit, there were some railroad tracks. And a homeless encampment started out there. The property owner realized it when she started seeing things through the trees there. And when they inspected it, the same was true. The amount of hazardous waste that was true. And the presence of people kept her from letting her children use the swing set in their backyard. And again, they were faced on their part of the property with an expensive cleanup after that. So this would prohibit it. It would make it a violation of law if somebody is camping on your property without your consent. And in fact, the police could enforce that immediately by just ordering somebody to leave. I'd be happy to answer any questions.
Thank you. Questions? Representative Scheer.
Thank you, and thank you for your testimony. What confuses me is why can't the police arrest somebody for criminal trespass for camping on somebody else's property as it currently stands?
So both of these constituents in this jurisdiction in Concord would have been the enforcing entity at that time, required them to apply to file a complaint that there was trespass happening to them. And then the police processed that and went out and served it. And in the best case scenario, it took 10 days for that to happen.
I guess I'm baffled by the conduct. I assume it's the Concord police. I'm baffled by that conduct because the criminal trespass statute, even if it's a violation, allows the police to get somebody off private property. If I were to just walk up to Representative DeVoyd's house and sat on the steps of his house, and he didn't want me there, he could call the police, and the police would come and arrest me for a criminal trespass. I guess I'm baffled by this, the police requiring this process to get the people off the property. I don't know if we're going to hear from any other witnesses, but I'm baffled.
Well, part of the question comes down to, okay, they could maybe move them along, but they could come right back without the no trespass order, and it would still just stay that violation, move along type of thing. Maybe. I'm not sure what they were thinking. Senator, if you could find out what the police said with regard to why they didn't just move them along, why they required that no trespass order. If the people know, I'm not asking you to go on a snipe hunt. Just if they know, we'd be curious to see why this is necessary when the current statute does allow the police to move them along. Representative Lascelles.
Thank you for taking my question. I'm curious about the 10,000 person limit with respect to the municipality. I understand that there's a bigger problem in bigger cities. I come from a city or a town that adjoins Manchester and very close to Hudson and Nashua. We have 9,000 people in our town. Is that like putting out a welcome sign for homeless to Litchfield?
I don't think it's putting out a welcome sign, but I think the evidence shows, and homeless advocates have told us, that homeless individuals, people who are unhoused, will locate someplace where there are services, where there is a food kitchen, where there is a place to do laundry. We have all of those things here in Concord, and where there's services and there is a welfare, a human services budget to help them out. So we didn't see that the small towns surrounding us were having any homeless issues at all. None of them indicated that they were. So instead of burdening the whole state with the law, the people that actually needed it and were looking for opportunities to have a provision like this, we centered it there. Thank you.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. I have a question on page 2, just the language, line 5 and 6, regarding additional penalty for camping on private property. Can you tell me what is meant by any person who violates RSA 236:58 shall be guilty of a violation if a natural person or guilty of a misdemeanor if any other person? What does that mean?
You can, my understanding, and there are attorneys here who could probably correct this. You could be, you could have a business, trailer or unit or something that you could put on somebody's property that was owned by a corporate entity. So that in fact is a trespass too, and a natural person being exactly what we think of a natural person.
So basically, it's a real human doing it versus a corporation doing it. Same offense, just different. Any further question? Excuse me,
Yes, so I share the same concern that Representative Scher raised earlier about why, but the other question I have is, if this were to pass, I'm wondering if this, could this be interpreted to mean, if we were to pass this, that since we've addressed it in this specific way, that what Representative Scher was saying about, the current law being, and I think I would agree with the way he interpreted it, that trespassing is trespassing. If we pass this, is there some chance that a court would later say, well, it's only if you satisfy this provision is there a remedy for trespassing, and what used to be trespassing is no longer covered. It's no longer a violation. In other words, an unintended consequence.
Representative Lynn, I think you might know the answer to that question better than I would, but this is specifically camping, that we allow in the state of New Hampshire that you're not allowed to camp on public property. The state could immediately remove you, but there isn't such a provision for a private property owner. One of these property owners is right beside some state land and saw a camp removed from that state land in an instance and didn't have the same benefit of this law in order to do that. And that's the constituent that asked me to bring this.
Thank you.
thank you. Seeing no further questions, thank you, Senator.
Thank you, Mr. Chair.
Chair calls Rachel Potter.
Good afternoon, Mr. Chair and members of the committee. For the record, my name is Rachel Potter, and I'm here in my capacity as Policy Associate at the ACLU of New Hampshire. So I want to begin by acknowledging that property owners absolutely have the right to control their land and to prevent individuals from staying on their property without permission. And as we've talked about here already, existing trespass laws already provide these protections and allow owners to request someone to leave if they're there unlawfully. Our concern with this bill is that it shifts the role of enforcement from property owners to law enforcement. And under this bill, the police would be authorized to initiate the enforcement on their own if they encounter someone camping on private property, even if the property owner themselves has not made a complaint. And specifically, this bill allows law enforcement to penalize someone for sleeping on private property without written permission, regardless of whether the owner has objected. So in practice, this would require individuals to produce written proof of permission on the spot, something that they may not have or may not easily exist. And without it, a person could be removed or, arrested based solely on an officer's inability to confirm that authorization. So here's an example. Maybe you think it's outlandish, but you're away for the weekend and your teenager decides to camp in the backyard with their friends. They obviously have your verbal permission, but nothing in writing. And a neighbor calls the police about activity on the property, or an officer happens to pass by and investigates. And if they're unable to reach you, or if they have no written proof of permission, the officer could conclude that your teenagers are trespassing and cite or arrest them despite the fact that they're here on your property with your consent. Another scenario, imagine a property owner informally allows a friend or an acquaintance who is between housing to stay temporarily in a tent on their property. This kind of arrangement, might be based on trust or verbal agreement, not formal documentation. If law enforcement encounters that individual and asks for written permission, the person may not have any. And even if the homeowner fully supports their presence, the individual could still be cited or arrested simply because they cannot produce written proof at that exact moment. So obviously the sponsor is trying to address homelessness in this bill, but this bill really does nothing to address homelessness besides prevent homeless people from potentially ever entering housing. For example, someone experiencing homelessness may choose to sleep quietly behind a closed business or in the corner of a parking lot overnight, simply to stay safe and out of the way of public spaces. But under this bill, a person could face enforcement even if the property owner never complained or asked them to leave. And we know across the country, the evidence shows that criminalizing sleeping or camping does not reduce homelessness. Instead, citations, fines, criminal records can create additional barriers to employment and housing, making it harder for people to regain stability and actually exit homelessness. So we know that New Hampshire is currently facing a serious housing shortage and rising housing costs, and policies that punish people for being unhoused just don't solve that crisis. And they simply make it harder for people and place burdens on them with legal consequences that make it even harder to secure housing. So ultimately, the bill expands law enforcement authority in a way that risks unnecessary police interactions and potential arrests, undermines the right of property owners that they already have, and ultimately does nothing to address the root cause of homelessness. So we are opposed to the legislation.
Thank you. Any questions? Seeing none, thank you for your testimony. Anyone else wishing to testify in this bill wasn't done so? Seeing none, I hereby close the public hearing. We will reconvene at 2 o'clock. We will be in recess until then.
So good afternoon. The chairman's going to be a couple minutes late, so I'm going to open the hearing on Senate Bill 620. And I'm going to recess it for 5 to 10 minutes, so I'm told.
I'm Senator Bill Cannon. Thank you for having me. I'm introducing 620, the DUI bill. I have Ryan McFarland sitting next to me just in case I blow a point of law. So I like to have learned counsel by my side when possible. And seeing that we had a room full, I decided to borrow him. 620. So mea culpa, mea culpa, mea maxima culpa. I'm not sure if the Latin's right. I apologize to my CNA's professor. I brought this bill before you before in different forms. And what I didn't have was like a human side. I always had myself and I had a police officer. And today we're going to do it a little differently. I want you to hear the impact of people. And they're going to express much better what happens to people when a drunk driver kills someone in their immediate family. I think the impact will be far greater than anything I can do. But what I can do, Matt, I just address you because I know you're newer. And so I've been learning a lot about the bill too, even though I've done it before. So the 620 does not criminalize, we'll start there, refusing submitting to a lie detector. So we're talking here about privilege. We're going to talk about implied consent. And so let's start back at the beginning. You get pulled over, Matt. And so they're going to give you some initial tests probably. And I don't mean to ignore anyone else. I know he's new, and I asked him if he understood the stuff of the bill, and he said he was new on it. So I'm just going to talk to you, but I'm really talking to everyone. So you get pulled over on the side of the road, and they're going to administer a test if they think they need to go further. They have to arrest you. I don't know if you're aware of it. I wasn't until more recently than I should have been, that you have to be arrested. I thought the breathalyzer they gave me at the side of the road was the breathalyzer. You have to actually go back to the station. They use a much better calibrated, bigger machine. So when if you blow over the .08, they're going to give you an administrative suspension of your license. So they're going to seize your license, and they're going to give you this long sheet, from what I understand, right, Ryan?
Form, correct.
Pretty long form. And so initially, driving is a privilege in New Hampshire. We should all be aware of that. If you're not, it's so when you have a privilege, you're under the law, you're obligated then to either give a blood, a urine, or a breathalyzer test. Otherwise, so that's a contract you've made with the state of New Hampshire. And now if you don't want to take that test, that's fine. You don't have to take the test, but you violated your contract with the state. And then you're going to lose your license. So right now it's 6 months, but it's a 6 months sentence. And if you don't take it though, it's a 6 months, you're going to lose your license for 6 months. So we don't really have any incentive to take that. A lot of people are going to tell the officer, should I take it, shouldn't I? And they're going to make a calculated decision that maybe I shouldn't take it. And I should, maybe I can go hire a good counsel, like some of the learned counsel behind me, and they can get me off in a technicality. Say your eyes are glassy, you work so long. They'll have reasons. They have a list of things they can look for that an officer might have made a mistake on. So right now, again, 6 months is 6 months. Why take the test? So 30 other states. So I wasn't sure last year when they presented me, and they're like, oh, if you go to 12 months, it's going to be a constitutional problem with 12 months. 30 other states do 12 months. In fact, Utah, a further state, 31st state on the other side, goes to 18 months. So it is constitutional, and the 12 months will not have a problem with it. It is not a punitive penalty. It's remedial. We want to take it, you or me or anyone who might be thinking about going over, we want them concerned that they're not going to drink as much. So as you're aware, probably in the news lately, Matt, you said you were seeing it, around an average of 70% of New Hampshire citizens refuse the test. Most of the rest of the country, I'm not going to go individual state, but it's around 30%. Hope you don't mind I'm talking to you. It's just you're a post for me to look at there. So 30% of the other states are refusing. And our death rate's higher. Everything's a little worse. But so if people are not worried about it and they're thinking they can get off, and they're thinking right away, I've had numerous state troopers testify that people are making a calculated decision not to take this test. We can't have it. So I don't want me on a Friday night, like some of the people in the back of the room, they've got calls, the officers at the door. And you know, when a police officer's at the door, it's not going to be good news about your daughter who you know is out, or your son, or your husband, or your wife. We have 40 a year losses, life loss on the road. But that 40 affects grandmothers, fathers, it's your only child. It's a horrible thing. I can't imagine you know, my kids, you've seen them out campaigning. I would be lost without them. So I don't know how some of these people are tough enough to go on and get through. But if we only saved 5 less people drinking, 5 more lives this year, I would say the bill was a complete success. If we saved 2 lives, but we're going up, it's gone up from 38 to 39 to 40. And I know the governor released a statement earlier today, I believe, in saying that our number was at an all-time high in the last 3.5 months. It's at a record-setting pace for DUIs. So this bill's about families. It's about protecting New Hampshire citizens. It has nothing to do with being a Republican or Democrat. All the Democrats in the Senate, Sue Prentice led the charge with me. She said she's going to come in and sign in. I'm not sure if she's gotten here, if she's going to have time to speak. But the Democrats all agreed with me that this was not a partisan bill. It's a bill about protecting people on roads. So a privilege to be on the road. So here you go, Matt. We're going back. So you've got an administrative license suspension. Simultaneously, there's a criminal part of this aspect. So within 20 days, is it of losing your license or when you're stopped? 20 days, they have to give you a criminal hearing.
When they request a hearing, it has to be scheduled within 20 days.
So within 20 days, if you request a hearing, they'll give you that hearing date. And so the good thing about this hearing is if it's your first time, you had some terrible thing happen in your life, your child died, your wife left you lost your job, you had 1 too many drinks, you made a mistake, not your normal course habit. In fact, it's out of your normal sphere of conduct. The judge can look at it and say, okay, you cooperated. We're trying to encourage people to cooperate and take this breathalyzer test. So you've cooperated. He can then say, and let's say you weren't aggravated. You weren't like 20 drinks. You were just a hair over, a little over. He can then use his discretion. So it's giving the judge discretion at this point to lower that. You can keep it down to 3 months. So you could complete the driver's course, to learn what you're doing wrong, what happens to drunk drivers, accident scenes, and you're sorry and you admit that you made this egregious mistake in your life. And so they can use judge's discretion and lower it to 3 months. So now you can get out in 3 months for what you've done, or you can live with you don't want to take that breathalyzer, 12 months. Taking the breathalyzer, you can back me up, Ryan, on this. It's not required that you take the breathalyzer, but it's not also a violation of your constitutional rights. It can't be used against you later.
The refusal can be used against you in court.
Okay, the refusal part can be used against you in court.
Correct.
Okay, so we've gotten the privilege. We don't want to have an incentive. We've looked at the judge, and that's probably where I should wrap up before I go into deeper water than I know how to swim. Do you have any questions?
Seeing none. Oh.
Representative Muse.
Aside from the fact that there's no non-germane amendment attached to this one this time.
Not yet.
What are the?
I'm anticipating there may be moments.
What are the significant differences between this bill as you filed it this year and the bill you filed last year?
Something I forgot to mention, which is a new thing too in this year. Your out-of-state convictions don't show up in New Hampshire. It's an unfortunate thing. So now your out-of-state convictions in Massachusetts with this bill will be recorded. So we can't get people who are coming here from other states and then hiding the fact that they have a driving problem. That would be one brand new thing that wasn't in the bill before. I don't remember the exact time period I asked for last year. There are differences in the bill otherwise, but I think the learned attorneys after me can point out the specifics. But that was one extreme difference is we've had a lot of problems with people. We find, they've killed someone and then we find out, oh, geez, they had a drunk driving truck. Why the heck haven't we caught up with that? It's something which should have been done a long time ago. But so now I didn't realize before that with the 6 months, there's no incentive to take that. But now I know that with the 3 months, the discretion of the judge, that makes me appreciate the bill more. So now there's going to be a difference. So that if you cooperate, you can get out in 3 months. You don't, it's 12 months. Big incentive for me it's a bigger, the distance between the two charges, what's going to be the administrative sentence of either, well, it's 6 months now, will be a year, as opposed to going to the criminal part of the procedure, which the judge can let you off in 3 is a huge difference and should be the incentive it takes to get people to want to take the breathalyzer. Whereas right now, there is no incentive.
I do understand what you're trying to do. It sounds really complicated.
Oh, it's really simple. No. So
Okay.
we're going to go to 12 months. And the reason is no one's going to take this test right now because it's 6 months if I take it, 6 months if I don't. And if I don't take it and I get a good lawyer, he might get me totally off. But we've made it, I'm much more aware now that the 3 months, most judges I'm hearing in the field are giving, if it's your first offense, it's a low amount. You're not an aggravated high drunk. You're not at a 0.24 or something where you're stumbling and falling over. It's a low amount. The judge can use his discretion. You're saying, I really screwed up on this time. It won't happen again. And he can take, look at you and decide, a judgment of your character, whether you're, a good candidate for reducing the sentence. And so we're giving him, I'm aware of his discretionary role for 3 months, which most people can get, versus the 12 months. If you don't want to take it, you think it's like a bodily intrusion, which the Supreme Court has said it is not a bodily intrusion for you to take the breathalyzer test. I think it's going to really reduce our amounts of DUI in New Hampshire, potentially. And again, if we saved one life, it was a win.
One more, yeah. One of the things that I've read is when penalties are increased, typically one of the things that makes those increases more effective is if they're communicated effectively. And I noticed that in the bill, there is nothing that really addresses how we're actually going to let people know that this change has taken place. And once the initial period ends where there might be a news story on WMUR one night and maybe a follow-up article in the Union Leader, what's the plan to kind of keep this in front of people so it actually does change their behavior?
Have you seen, I think Lieutenant Storm has done a number of different subject matters. I've seen him on the air a lot, other troopers from the state police. And so I think the plan is to radio, TV, we're going to let kids know if you drink and drive, it can be 12 months. And we want people to take this test and you can get out in 3 if you're willing to cooperate. So we're looking for people to work. Again, we're looking to save lives. We're not looking to push any partisan agenda here. It's the 12 months is to have a big differentiation. And again, it's illegal. It's legal because 30 other states are doing it, and a 31st is doing the 18 months. So that used to be in question. It was brought to my attention. People said, "Oh, this won't be constitutionally acceptable." And then I looked up, well, it's working in 31 states, so it can work here too. And I think it'll make any challenge. But I can see Lieutenant Storm on TV doing good ad campaign. The state police will fund it. Every single law enforcement agency in the state is behind this bill, and they have the means to put it on the air. So TV, radio, newspaper, I think is the plan. But I got to get it over the finish line first.
Thank you.
I have it on good authority that the governor will probably be doing a PSA herself on this if we,
Sure, I have heard such.
if we manage to get it through.
Such talk.
Further questions? Seeing none, thank you. I
Thank you very
apologize
much.
missing, but
No.
being a single guy, my dog needed to go out.
Okay. We all have duties.
Yes.
Thank you very much, Sherry.
You're
Thank
welcome.
you, committee.
Who's next? Okay, just for so everybody understands, after the prime sponsors have spoken, we have 14 people going to speak. We're going to limit testimony to 3 minutes, please. So if you're going to testify, keep it to the 3 minutes. If you're going to say something that someone's already said, please don't do that. But if you have something unique to share with us, by all means, do so. So with that, I would call Representative Markell.
Thank you, Mr. Chairman and committee, for letting me address this bill. I speak in support of it as a practicing attorney with criminal defense experience. I was admitted to the New Hampshire Bar in 1998. My criminal experience includes federal and state criminal work and includes also drunk driving defense and operating under the influence in both Massachusetts and New Hampshire. I speak in support of this bill for a couple of reasons. Number one, My reading of the situation is that I think it will save lives, and I do think there's a causal effect between getting people who are impaired off the road. And for example, those who are trained in drunk driving know, if you read the NHTSA manual, which is where most of the training goes for drunk driving, people who consume alcohol and drive and are impaired haven't done it once. They've done it quite often before they finally get caught. Number two is that we heard talk about the Intoxilyzer, which is typically the machine that's been used in the past in New Hampshire. Most people, to my knowledge, many of the law enforcement agencies have abandoned this machine. Back in 2008, I started leading a charge, if you want to call it that, against the Draeger Mark III in Massachusetts, which basically uses computer software to try to analyze your breath. The machine was found to be defective. This does not limit unduly a criminal defense lawyer's ability to challenge the evidence, particularly in relation to the Intoxilyzer 5000, if that's the one still being used. The gold standard in this particular line of work is actually a blood test. So most police departments and law enforcement agencies will opt in favor of that. To my knowledge, there are no constitutional problems with it. It's implied consent. I see a causal relationship between increasing the administrative sanctions for people who refuse tests and getting impaired drivers off the road. I'd be happy to take any questions based on that on a 3-minute limit. Thank you.
Thank you. Any questions? Seeing none, thank you for your testimony.
Thank you, sir.
The chair calls Rep. DeSimone.
Thank you, Mr. Chairman and committee. I come before you today to tell you something that is near and dear to my heart. About a year ago, my husband and I were out for an evening. We came home during the daylight, right after the multitude of small children went in the house for the evening. It was still daylight. We turned into our driveway, and lo and behold, I was one of those people who was facing a police vehicle. It scared the heart out of me. We drove in. We said to the police officer, "What can I do for you?" And he said, "I need to tell you that part of your fence is now missing because there was a drunk driver who was pretty much like a pinball machine. It seems as though she came around the corner doing a very, very, very fast speed and was like a pinball machine going back and forth, back and forth. She took out a mailbox. She took out part of my tree. She took out a fence piece. She took out my fence piece and then landed in somebody's yard on a car." The point of this is, had those children still been out, or had my husband and I come home 10 minutes earlier, somebody would be dead because she was a repeat offender. If this bill is passed and this bill goes through, she may not be on the road again. I never want to go home again and see another police vehicle in my yard unless that police officer needs a cup of coffee. I thank you so much for your time. I thank you for listening to me. And I will take questions, but I'm sure you don't have any. But that's okay if you do.
Did you get your fence fixed?
Not yet. She has no money because it goes to the nearest gin mill. So I haven't had my fence fixed. That's okay.
Let that be a warning to everyone to have good homeowners insurance.
There you go. I'm not putting it in. My rates will go up.
Thank you for your testimony.
Thank you.
The chair calls Beth Shaw.
Good afternoon. Thank you for having me here. My name is Beth Shaw. I am here in support of Bill SB 620, The purpose of this bill is to act as a strong deterrent to ensure public safety and save lives. My 20-year-old son, Tyler, was killed by a repeat offender in 2018. Weeks before his death, Tyler made a list of 29 life goals. Number 1, he wanted to make $1 million. Among others, he wanted to become a top general contractor of the state, own a house by 25, maintain a successful marriage, learn to be a great father, and make his family proud. None of those dreams or goals will ever be realized, all because one person decided to drink and drive. Words fail to express the impact Tyler's death has had on our family. Our lives have been shattered. Our family will never be whole again. Tyler's death is not just the day he died. It is every single day when we wake up and remember Tyler is never coming home. And yet Tyler's death was completely avoidable. Don't drink and drive. It is a very straightforward law. Yet the number of deaths due to impaired driving is steadily climbing in New Hampshire. Every time an impaired driver gets behind the wheel, everyone on the road is a potential victim. God forbid it is someone you love. It's simple. A sober driver will never refuse a breathalyzer or a blood draw to prove they are not impaired. An impaired driver will. When it comes to rights, let's be clear. A driver's license is a privilege. It is not a right. Some lawmakers feel that increasing the length of a license suspension infringes on drivers' rights and freedoms. They've expressed that they feel the increased license suspension is a hardship. I respectfully challenge that thought process. As a mother whose son was killed by a drunk driver, I believe that protecting the offender's rights and freedoms should not be the priority, especially following a failed field sobriety test. The priority should always be everyone else on the road. As for the perceived hardship, let me ask, who is truly enduring the hardship? Is it the impaired driver who is putting innocent lives at stake? Or is it the potential victim who is enduring the hardship? The victim who is seriously injured or killed? The victim who might never go home? Losing your license for 1 year after driving impaired is not a hardship. It is a self-imposed consequence. Losing your life, there should be no question, that is the hardship. I can't help but feel our lawmakers are more concerned for those driving impaired than for the possible victim of this crime. Knowing the number of impaired driving deaths in our state is rising. Knowing New Hampshire has a 70% refusal rate, the second highest in the nation, should be reason enough to pass this bill. Yet the majority of concerns are about the rights and freedoms of a driver who has failed a field sobriety test. A driver who did not hesitate to lose their license for 6 months because they refused further testing, which would exonerate them if they are sober. That is not protecting the rights and liberties of everyone else on the road. That is protecting the offender. For legislators who may oppose this bill, I would encourage you to ride along with law enforcement to an impaired driving crash. Witness firsthand the brutal, horrific death of an innocent victim. Accompany the officers to notify the family that their loved one was killed by a drunk driver. Then ask yourself if this legislation is important to pass. The worst thing that ever happened to me was answering my door in the middle of the night to 3 officers who told me my son was killed tragically by a drunk driver. I am urging lawmakers to pass this bill to save someone else from having to answer that door. Thank you.
Thank you. Chair calls Karen Bowen.
First, let me say thank you for allowing me to speak. My name is Karen Bowen, and I am a survivor of drunk drivers. Have you seen the crosses alongside the road? I have 1 and 2. February 1st, 1964, my Aunt Elzita, 34, I was 12. On September 20th, 1986, her sister, my mother, Georgiana, age 59, I was 34. In 1964, the laws were non-existent. In 1968, the laws were catching up. I have sent many impact statements to judges with my opinion on impaired drivers. Both young men were repeat offenders. Today we look upon the vehicle as a pleasure. They are not. They are a necessity, and most of all, a lethal weapon, no different from a gun. The laws have to grow with the times. The law has to show that there is a consequence for their actions. You have to live under a rock not to know about drunk driving or impaired driving. It is advertised everywhere. I believe the penalty should be increased to 1 year. I would really like to, because of my history. Here is another way to look at this bill, as it may save a life. I would go one step further and make it that if they are caught driving on that suspended license, that they do the remaining time in jail. The penalty must be strong because the loss of life may be someone you love or know. In closing, I'd like to say these parting words. I want to say thank you to all the police officers in the room. They have my respect. And I pray to God that you and your family are not touched by the loss of a loved one, drunk driver or impaired driver. I can tell you it changes your life forever. Thank you.
Thank you. Chair calls Alicia Miles.
Good afternoon, everyone. I'm Alicia Miles. I'm from Vermont. I am here today in support of the SB 620 bill. Before May 27th, 2023, I was living the life that I have always dreamed of, a new home, a fulfilling career, 2 dogs, my loving husband, and my beautiful, amazing daughter, Olivia. But in an instant, everything changed. That day became the moment that split my life in two, the before and the after. Olivia was born on February 26, 2017, and from the very first moment I held her, I knew she was going to be my whole entire life and my best friend. The best way I can describe Olivia to you is pure sunshine. She was the easiest baby right from the start. She hardly ever fussed, and as she grew, she continued to amaze me by being the kindest, most loving, and most incredible child. She was always such a people person, loving everyone she met. Olivia gave everything 110%, from cheerleading and gymnastics to ninja warrior training, horseback riding, soccer, and t-ball. On the morning of Saturday, May 27th, 2023, we got up. Olivia had her favorite Cocoa Puffs for breakfast. I braided her hair and we headed out to her t-ball game at her school. Watching Olivia play t-ball was one of my favorite things to do. She'd hit the ball with all her might. Her bat would fly through the air. She'd run as fast as her tiny legs could take her, kicking up dust behind her. After her t-ball game, we went to my mom's house for dinner. Olivia spent the evening playing with her 2 cousins. We set off to go home and we stopped to do some shopping. Olivia and I went to Old Navy while Chad went to Dick's. As Liv and I walked to Dick's to meet Chad, we were holding hands. She looked up at me and said, "I love you, Mama," which wasn't unusual for her to do, but never in a million years did I think it was going to be the last time I'd hear her say that. When she saw her daddy, she ran up to him and hugged him. He showed her the new t-ball glove he picked out for her, and it was a glove she was never able to wear. We continued on our way home, and we were almost there. We crested a hill, and all I saw in front of us were headlights. The last thing I remember is yelling, "Oh my God," to my husband who was driving. We were hit head on by a speeding drunk driver. I came to hearing Chad yell my name over and over, and I immediately turned around and started yelling for Olivia, who was in her car seat behind me. I turned and I saw her slumped over, which will forever be an image burned into my head. Chad got her out of the car, and I saw she still wasn't moving, and I just started yelling at him to do CPR. We got into a passerby's vehicle, and he took us as quickly as he could to meet the ambulance, as my husband was still doing CPR on our baby in the back seat. We met the ambulance and handed her off to them, and I remember telling myself they were going to save her. When we got to the hospital, they put us in separate rooms. I was demanding to know what was going on with my daughter, not letting nurses touch me. I was refusing all tests, just wanting to know what was going on with her. A doctor finally came in my room, looked me in the eyes, and said, "Your daughter didn't make it." In that very moment, I knew I wanted to die too. I had scans done, and I was put in a room with my husband. Then they rolled our baby's lifeless body in for me to hold her hand. She looked like she was just sleeping. She was warm, her clothes still intact, and her hair still in braids from the morning. There was so much happening around me, so many people, and I don't remember anything except staring at her and holding her hand as tight as I could, never wanting to let go. Staff came in and said I needed to be in emergent transport to another hospital. I woke up a day or so later with severe injuries, my wrist in a cast, my stomach stapled shut from life-saving surgery, a tube up my nose and down into my stomach, and bruises covering my whole entire body. We had 3 days of services for Olivia, and it's all a blur. On June 12th, 2023, I said my final goodbye to my daughter as I watched them lower her casket into the ground. It's a pain I couldn't ever describe to you. The weight of that goodbye doesn't just stay in the past, it's with me every second of every day and has changed every aspect of who I am right now. Life immediately after was trying to survive minute by minute, and when that got too hard, it was trying to survive second by second. I was having nightmares, which still occasionally happen, where I wouldn't sleep at all. I was a shell of a person and I wanted to die. I asked my husband to secure all the firearms in the house, and I had my mom just giving me the doses of medication I needed and hiding the rest. I knew if I really wanted to end my life, I had the means to, but I didn't want to make it that easy on myself. As I'm sitting here today, I carry with me a pain no parent should ever have to hold. The loss of my beautiful daughter, Olivia. Her life was stolen in an instant by a choice, a selfish, preventable choice someone else made. Olivia is more than a name and a headline. She was laughter, light, and love. She had dreams and she had a bright future. All of that was taken from her and from us because someone else chose not to think about consequences. I share Olivia's story, not to get sympathy, but to inspire change. So today, as I leave here, I ask you to carry Olivia with you. Let her name and her beautiful face be a reminder that she isn't just a statistic. She is a real person that so many people love. Olivia is my reason why I support this bill. Thank you.
Thank you very much. Chair calls Commissioner Edwards.
Good afternoon, Honorable Chairman, Honorable Committee members. For the record, my name is Eddie Edwards. I am the Assistant Commissioner at the New Hampshire Department of Safety. To my right is Bureau Chief Ryan McFarland. To my left is Captain Amatucci. They will formally introduce themselves during their testimony. We understand the 3-minute limit, so we will be brief in our testimony to make sure that we have time for your questions.
The questions don't count against it, and I see 9 minutes sitting there, so you're good.
Thank you. I won't take all of that. So, first, thank you again for giving us an opportunity to testify today. And we're very excited to support this legislation. It's one of the governor's top priorities for this year. Additionally, this legislation came about from a special task force that the governor stood up to look at highway safety in the state of New Hampshire. That task force was made up of different members throughout our community, different professions, many elected officials, prosecutors, police officers, a whole array of people to look at this issue. And it was also a recommendation from that committee. What this comes down to is behavioral choice. This is a behavioral choice. And listen to this testimony that you just heard from these victims. There's no way that we couldn't support this type of legislation. There's no way. This is not about an attack on freedom. It's not about an attack on liberty. It's the opposite of that. In fact, it's very difficult to have liberty and freedom without accountability and responsibility. Those are the essence of liberty and freedom. That's number one. Number two, this is the most preventable, one of the most preventable forms of death in our society. It is 100% preventable. Every single person who has made a personal choice to drink and drive did so freely. All we're asking for is a consequence that matches the public messaging that drinking and driving will not be tolerated in our state. And you heard just a moment from 3 people who are victims of that. So there's no reason why New Hampshire would not have a policy that matches the enforcement effort, that matches the prosecution effort, that matches the expectations of parents and young people throughout this state. That's all we're asking for. I can tell you personally, when I'm asked, what are you doing about DWI? What are you doing about this type of offense? What are you doing personally in my role? We're putting more law enforcement out on the roads. We have enormous amounts of money spent to prevent DWI. We have messaging constantly. The state has dedicated nearly $750,000 on education messaging to make sure the word is out. And yet, we do not have a public policy that matches that. The consequence for refusing a test, by the way, that you agreed to take. You have a legal obligation to take this test if you hold a New Hampshire driver's license. You agreed to that. There's no reason why the consequences for your actions would not match that. And lastly, this is something that I am confident that every single person in this room tells the young people in their lives. You are accountable for your actions, your behavior. You are personally accountable for that. Thank you.
Thank you, Mr. Chair. Committee members, for the record, my name is Matt Amatucci, and I'm a captain with the New Hampshire State Police. New Hampshire faces a persistent public safety challenge, an exceptionally high rate of post-arrest refusals of chemical testing by impaired driving suspects. Historically, our refusal rate has been among the highest in the nation, at 81% in 2005 and 70% in 2025, while the national average hovers around 24%. The problem undermines enforcement and accountability for impaired driving and truly demands legislative action. The Administrative License Suspension ALS framework is the nation's leading and most effective countermeasure against impaired driving because it delivers swift, certain, meaningful consequences, removing dangerous drivers from the road immediately and independently of criminal court timelines. The principle is clear. Drivers are less likely to offend when sanctions are swift and certain. The Department of Safety respectfully urges the committee to recommend ought to pass on SB 620 by reinforcing the ALS, tightening the refusal consequences while pairing sanctions and treatment and technology such as the interlock systems. This bill delivers the swift, certain, and fair framework that saves lives, reduces recidivism, and restores confidence in impaired driving enforcement. Granite Staters deserve roads while impaired drivers are deterred, detected, and held accountable, and where those who choose to cooperate and complete treatment have a path to rehabilitation. SB 620 provides exactly that balance, and we request your support. Thank you.
Afternoon, Chairman, members of the committee. My name is Ryan McFarland. I'm the administrator of the Department of Safety Bureau of Hearings. I've also been a lawyer in the state of New Hampshire for over 20 years. We're here in support of this bill today, and I want to talk just quickly about parts of the bill that are often overlooked as well. One that closes a loophole that I think these victims have shown, and that is the repeat offender. Right now, with the way the administrative license suspension law works in New Hampshire, we do not consider out-of-state convictions or out-of-state implied consent administrative suspensions when we determine whether somebody is a first-time offender or a repeat offender. We only consider in-state convictions or suspensions. Okay? The court, the criminal system considers out-of-state convictions or equivalent offenses. The habitual offender law considers out-of-state offenses. But for some reason, there is a loophole in the administrative license suspension law that does not consider it. So if it is an individual who gets convicted of a DWI or OUI in Massachusetts or Vermont, or has an administrative suspension in that state, comes to New Hampshire, gets stopped for DWI, they refuse, it is a 6-month refusal, even though they have a prior DWI related offense. So that is an important loophole that needs to be closed, because you've heard from the victims that these are always repeat offenders. That's a strong loophole that I think needs to be part of this bill and needs to be addressed. Also is fairness. Everybody wants to be fair. Currently, right now, the way the laws read, an individual who submits to testing and is above twice the legal limit, a 0.16 or greater, and submits, does what we've asked them to do. They're charged with an aggravated DWI. They could possibly go to jail. They lose their license for a longer period of time. They have to have an interlock. While individuals who all of these officers in this room today could point out and say that person is clearly above the legal limit. They're clearly above twice the legal limit. They're probably 3 times above the legal limit. If they refuse, do absolutely nothing, and do not follow the contract they have with the state, and do not do what we ask them to do, they'll get charged with a DWI first offense, a minimum fine, counseling, and a loss of license of 9 months down to 3 months. And so what this bill also addresses is to make it equal. We're now penalizing people for taking the test instead of the opposite. We should be penalizing individuals who are refusing the test, refusing that contract. The numbers are there. People are going to talk about the numbers, the refusal rate. I have written testimony, so I won't go over all the numbers, but the state of Vermont has instituted a very severe refusal framework, and it has worked. Their numbers have dropped drastically. Okay? One shocking number I'll leave you with my testimony, and we went over this yesterday with the assistant commissioner. Between January 1st of 2025 to today's date, we've had over 700 DWI arrests in the state of New Hampshire. And that to me is staggering when we look at that 2.5-month period of time. So any questions, I'd be more than happy to answer.
I just have one. So in states that have corrected and have fixed this refusal limit, I understand the refusals went way down. The metric I'm interested in is how much did their DWIs or OUIs go down after that? Do you have that information by a percentage, just to show how effective it was in those states?
I don't have information or numbers. I don't want to give numbers off the top of my head. I can get the committee numbers, but it provides information, obviously, because the problem is when individuals are refusing, they're refusing field sobriety tests, they're refusing any chemical tests. There's very little information for the police officers to go off of. Now, when you have scientific data, either through blood tests or, I know there's some testimony, the Intoxilyzer has now been updated. It's Intoxilyzer 9000. There's more technology there that provides that information for the courts and for the police departments to use in battling this DWI crisis.
Thank you.
If I may.
Yes.
These laws have also been proven to be very effective on recidivism rates. That's an important piece here. We don't want people to continue to drive drunk afterwards. You heard about the second offender, the third offender.
Thank you. Representative Muse.
When a person is actually stopped for DWI and I take it they're arrested, if the officer thinks they are under the influence, what does the officer actually say to the person they're arresting in terms of the test? And what will happen if they take the test? What will happen if they don't take the test? Is there anything like almost like a Miranda warning that applies so people understand what they're getting into?
Yes, thank you for the question. The administrative license suspension rights form is read verbatim to them. And then on the back of the form is all of the procedures that follow that.
But there's no interaction per se, and when it comes to the officer actually informing the person who's actually accused of their right to refuse or not to refuse? I'm a little, I'm
That's
I'm
the-
just
that's what he
curious what
reads.
what this looks like in real life when
Yeah,
somebody's
the
stopped
administrative
and
thing,
arrested.
that, go ahead, is actually what he reads to
So
them.
there's an administrative license suspension form. I actually have copies I can give to
Yes.
the committee members if you wish. So what happens when a
Apparently
law
they didn't
enforcement
read it.
officer arrested an individual for DWI, they either roadside or back at the station will read over that form. That's part of the administrative hearing we have, the process to make sure the law enforcement officer is following that. And as you will see, they have to go through line by line, informing the individual that they're requesting a test. First of all, that they've been arrested, they're requesting a test, that the license will be suspended if they blow over the test, that their license will be suspended if they refuse, their right to additional testing. They either have a right to have a partial of the sample if blood is taken, or they can get a blood test if a breath test is taken at their own expense, that the refusal is admissible in court. And then on the back side of that, which would be the second page of the document I handed out, that goes through other additional rights that they have. So that form has to be informed, the person has to be informed of all those rights, and the officer has to submit that to the DMV within a timely manner for there to be an administrative action taken.
One quick follow-up. Just looking at the first 6 lines, it doesn't look like it mentions any kind of a penalty or anything like that. So, you know, I guess in the spirit of helping people understand the consequences, is that somewhere else on the form?
The back side says there should be a second page.
And all this gets read to the person?
The first 6 lines get read to the
Okay.
individual.
But not anything on the second page?
Not anything on the second page.
Not right now.
No, the way the courts have indicated that the second page does not have to be read to them. They just have to be informed. Because there's always a question of the arresting officer may not know if the person has a prior conviction in another state or a prior refusal or something of that nature. So the courts have indicated that the officer should not be giving the person legal advice or probably incorrect advice by informing them of the length of the suspension. But the person themselves will know whether or not they have a prior conviction or not, or a prior refusal. So when they read the form, they'll know at that point.
Thank you.
Representative Prue.
In your opinion, when you're stopping these people, are they aware of the difference between taking the test and not taking the test, what that penalty means and how it affects them before they even read that form or that form is read to them?
Thank you for the question. I think it's individual by individual. I couldn't speak. Obviously, if they've been through this process in the past, they probably have a better understanding of what the consequences are. It also varies state by state. So I think it just really depends on who the individual is.
Follow up. Would you believe in my circle of people that I know, they're all well aware of the difference and how to get out of it?
I would believe that. See no further questions. Thank you very much.
Thank you.
Chair calls David Rodriguez.
Thank you, Mr. Chair and members of the committee. For the record, my name's David Rodriguez, and I am the Commissioner of the Department of Transportation. I just want to start by thanking the people who have testified before me. This is some of the hardest testimony I've heard in a hearing before. The state of New Hampshire and our local partners spend an incredible amount of scarce resources to keep our roadways safe. New Hampshire DOT alone invests tens of millions of dollars each year to keep our roadways safe through reconstruction projects, guardrail projects, roadway marking, signing projects, centerline rumble strips. We do a lot of work that is safety related. Despite our best efforts and significant investments, we have not been able to significantly reduce fatal crashes. We often talk about things we control and things we don't control. One of the things we don't control is driver behavior. We work to influence that through public media campaigns and so forth, and we work to influence that by supporting laws like this that put in place tools that can be used to help change driver behavior. The factors that we see in most crashes include impairment, speed, and distraction. Those are human choices that we don't get to control. Today we come to ask for your help to give us another tool in our toolbox that does influence driver behavior and does help to make some effective use of all the resources that we invest to try to keep our roadways safe. Thank you very much for your time, and
Thank you. We appreciate your time as well. Chair calls Dan Goodman.
Thank you very much. For the record, my name is Dan Goodman. I'm the Public Affairs and Traffic Safety Manager for AAA Northern New England. Chairman Roy and members of the committee, thank you very much for having me. AAA represents more than 1 million members across Maine, New Hampshire, and Vermont, and we advocate for policies that make our roads safer. I'm here today in support of SB 620. At AAA, roadway safety is at the heart of what we do every day. Impaired driving remains one of the most persistent and preventable threats to our roads. We are actively engaged with the state on traffic safety efforts. AAA partners with the state on public awareness campaigns highlighting the dangers of impaired driving. These efforts reinforce an important point. Strong laws, consistent enforcement, and public education must work together to change behavior and save lives. In New Hampshire, alcohol is a contributing factor in 39% of traffic fatalities. Since 2018, more than 260 lives have been lost in alcohol-related crashes in the Granite State. That's 1 every 10 days. Research shows that the average impaired driver has driven under the influence around 80 times before their first arrest. What we call a first-time offender is often someone who has taken that risk many times before finally being stopped. New Hampshire also has one of the highest breath test refusal rates in the country, as you've heard many times, with nearly 70% of suspected impaired drivers refusing testing each year. This matters because BAC evidence is often the single most critical piece of evidence in a DUI cases. Without it, cases are harder to prosecute, accountability is reduced, and the system becomes less effective. Refusal also weakens deterrence. When drivers believe they can avoid stronger consequences by refusing a test, it creates a loophole, particularly for high risk and repeat offenders. SB 620 closes that loophole by increasing the penalty for test refusal, helping ensure that refusing a test is not an easier option than failing one. Stronger refusal penalties support law enforcement, improve accountability, and help ensure impaired drivers receive appropriate consequences and interventions. This is a simple step that will help prevent crashes, save lives, and make our roads safe. For this reason, we ask you to support this bill. I'm happy to answer any questions. Thank you very much.
Seeing none, thank you for your testimony.
Thank you.
Chair calls Celeste Clark.
Good afternoon, Chairman and members of the committee. I have to apologize. I don't have my voice today, so I have written testimony. My name is Celeste Clark, and I am in favor of SB 620. I work closely with the children in our youth coalition, the Raymond Coalition for Youth, and I just, real quick, the testimony says it in writing, but all of the students who go through civics classes or law classes in high schools across the state of New Hampshire know about the law as it is right now. So if we talk about prevention, changing this law to 1 year, that'll be educating all of the students who are coming through the school districts and learning about the laws in the state of New Hampshire. So I just, again, it's in writing, but due to my voice, thank you.
Thank you. Thank you for your time. Sheriff Wright and Sheriff Newcomb, would you like to come up together, or did you want to go separate?
Together, sir.
Thank you.
Good afternoon, Chairman Roy and the members of this committee. I'm Sheriff Bill Wright, Belknap County Sheriff.
I am the president of the New Hampshire Sheriff's Association, representing all 10 county sheriffs here in the state of New Hampshire. I'm also a 28-year full-time law enforcement veteran here in New Hampshire.
My name is Brian Newcomb. I'm the sheriff of Hillsborough County, and
So we are here in support of Senate Bill 620. We have a different kind of take on this, where we think that not only do we support everything that all those who came before us had stated, but we also think that this Senate bill actually protects the constitutional rights of the people who are placed into custody and given the opportunity to take the ALS test. The test actually ensure that the individuals aren't wrongfully charged or convicted based solely on a subjective observations of what the officers saw at the given time, and that it actually reinforces due process and fairness. It promotes evidence-based enforcement, where it's actually encouraging the reliance on objective and viable measures rather than solely observational indicators of impairment. So again, with a test, it helps support whatever the observations of the officer has at that given time. It also recognizes any type of medical realities that might be going on. There's several instances where people are in diabetic emergency that they never even knew that they were diabetics at the time. We believe that, with the implied consent and having to be required to take a test, and having the incentive of taking the test, and they won't necessarily lose their license for 12 months. We think that that's a positive. We'll encourage them to take the test, and then we'll have that information. It also addresses BAC limitations, where blood alcohol levels might be below the legal limit, yet a person might still appear that they're impaired due to other things such as fatigue, illness, or other non-alcohol related factors. Those are things that we want to make sure that we capture while we're out doing our job. Again, people can present as they're impaired, but yet have some other factor going on. It reduces the risk of misidentification. In other words, it's going to help prevent situations where individuals are misjudged as impaired when the root of the cause is entirely something different. Again, these tests are important to help support what the observations are that we have and whether or not the observations are exactly what is happening in the scientific world with the capture of this test. It supports a balance of law enforcement responsibilities. And basically, it reinforces that law enforcement role is not only enforcement, but it's also the protections of people's rights and ensuring accuracy in determining impairment. Again, our job is to protect people's rights. It's the rights of the motoring public. It's also the rights of those who we believe to be impaired and that we're taken into custody. It ensures better training and awareness. It promotes increased understanding among officers of medical and environmental factors that can also influence behaviors and the appearances. It builds public trust. I believe right now that there's a problem with public trust. They think that these tests are going to give false readings, or that they really don't know what their blood alcohol level is. So it's easier to say, I'm not interested in that, thinking that that they are probably over the limit. Maybe they're not. But we believe that, with the influence of knowing that you're going to lose your license for 12 months because of Senate Bill 620, if you don't take the test, maybe it'll be that incentive to go and take the test, and we can actually find out what's actually going on. So we do believe that the public trust will be there. It also prevents unintended harm. So the likelihood of reduces the likelihood of wrongful arrests, legal consequences, and long-term impacts on individuals who are not actually impaired. Again, we're doing things based on physical tests and observations that we make roadside. And then when we take them into custody, what we have going on at our local police departments. So again, this helps reinforce what it is that we're seeing, or it helps rules out what it is that we're seeing, that there's some other issue. We believe that, again, to build a public trust, we need to have Senate Bill 620 passed with the incentive that in the event that they choose not to take the test, that there's a severe consequence to that. So hopefully it'll encourage them to actually take the test, and we can get secure data that actually supports what it is that we're doing out there, and that they're either impaired or not impaired. And we hope that this committee passes this with ought to pass and supports Senate Bill 620. We're open for any type of questions.
Seeing no questions, appreciate your time, Sheriff.
Thank you very much.
Chair calls George Fiol. There you go. And Chief Crowley, you as well? I didn't see Chief there, just saw George.
Good afternoon, Chairman Roy, and members of the Criminal Justice Public Safety Committee. My name is George Fioli. I'm the police chief in Derry, New Hampshire. Joining me today is Chief Tim Crowley from the Atkinson Police Department. I am the secretary of the New Hampshire Chiefs of Police Association. I appear on their behalf. Chief Crowley is our immediate past president. We appear strongly to support Senate Bill 620. I don't think there's anybody here that would argue that impaired driving is one of the most deadly offenses on our roadways today. An offense that is totally preventable, by the way. The Chiefs Association supports Senate Bill 620 for the following reasons. For far too long, suspects who have been arrested for DWI will refuse to take the test in order to secure a more favorable outcome for their reckless behavior. The advice most defense counsel give to folks in this circumstance is, if you've been drinking, don't take a test. Their reasoning is varied. They ask for a hearing from the Department of Motor Vehicles, which is usually somewhat of a trial in front of a hearings officer. The officer must show articulable suspicion for the stop. The officer must be able to articulate the failure of field sobriety tests. The officer must then show probable cause for the arrest, that the defendant was read his implied consent, and that's that form that was introduced a short bit ago, and that he or she refused to take a test. Lastly, if there were previous offenses, the officer must introduce those offenses for consideration by the hearings examiner. Often the hearing is used as a bargaining tool, whereas the defendant will negotiate a plea to a lesser offense of reckless operation with the preceding DWI charge and the administrative license suspension being dropped because there was no chemical test. The lack of that test often, and the lack of that evidence often leads to sway a jury or a judge to a not guilty finding. To be clear, this is not a new law. We just simply seek to enhance the penalties for revoking the implied consent we all gave when we received our license from the state. The increase in penalty for refusing a test will affect only one group of people, those who choose to drink and drive. If you take a test and blow under the 0.08 limit, you will likely not be charged with DWI in the first case. This law does not mandate anyone take a test. If the increased penalties save just one life by making people think before getting behind the wheel of a car, this law will be a success. We've heard testimony today that New Hampshire has the second highest refusal rate in the country. That indicates that we don't have the right tools in our toolbox to change that behavior. Senate Bill 620 provides us the tools we need to change that paradigm. We urge that you vote ought to pass on Senate Bill 620. And with the chairman's permission, I'll yield the microphone to Chief Crowley.
Thank you very much. Appreciate the indulgence. I sat on the Highway Safety Task Force last year when a lot of this was discussed. And I think there's an issue that it was actually brought up to me, and it reminded me of the situation when I heard Beth Shaw speak last week at the press conference and listened to the story of her son Tyler and how that occurred. I've been a police officer almost 43 years now and have investigated thousands of accidents. I did crash reconstruction for a long time. And the thing that was most frustrating to most police officers is when you go to an accident that involves an impaired driver, was the number of times that you went and an innocent person that has nothing to do with their bad decisions get affected, whether it's property damage or personal injury or at worst a fatality. And one of the worst duties of a police officer I was reminded of from listening to Beth, because she will tell you that she remembers that knock on the door. And she remembers that moment that the police officers made that notification. Well, you know who else remembers that very clearly today? Those officers that had to make that notification. Over the course of my time, unfortunately, I've had to do that on several occasions. And you realize it is absolutely the worst job that we have, is to walk up to somebody in their house and tell them that their child is not coming home. I can remember them as clearly today as I did when I made those notifications. Walking up to the front door of a house at 2 a.m. and realizing in about 30 seconds, you're going to destroy their world. So after you make the notification and you stand there and you watch the reactions and the emotions, and you try to offer some consolation, but there is none. So you sit there and you do everything you possibly can for them. And inevitably, over the first couple of minutes, two questions come out. The first one, what happened? And you can give them a pretty good idea based on the evidence of the crash scene and maybe some witness testimony as to the mechanics of the crash and what happened. What's the second question? Why? Can't answer that one. We would sit there very frustrated. We don't have an answer for that. Why did this happen to us? I don't know. Why is my child gone? Can't answer that. Why did this person make that decision? That's a very frustrating situation for us and that we have to deal with all the time. This legislation, Senate Bill 620, will help reduce the number of times that a police officer has to sit with a family and try to explain the why. So I urge you to pass this law, to get this bill through to the governor, and let's all get on the same page of making the roads of New Hampshire safer than they've ever been. Thank you.
Happy to answer any questions, Mr. Chairman.
Thank you for your time.
Thank you.
Chair calls Alexandra Romero.
Good afternoon, Chairman and members of the committee. I'm Assistant Attorney General Alexandria Morell from the Department of Justice. I'm also New Hampshire's Traffic Safety Resource Prosecutor. I'm handing out my written testimony. You will probably want to flip to page 3. Sorry that I didn't fold them ahead of time, but it has a nice chart on there. I think everybody is kind of confused what's going on, and so I wanted to make sure that you have a visual representation. I'm a visual learner of kind of what happens when somebody is arrested. So you have this traffic stop. An officer sees signs of an impairment. They have probable cause for arrest. Then they read the form that you received, the DSMV 426. And if the person refuses, so they've signed that they understood their rights, they signed that they are refusing, then two things happen. There is an administrative track and a criminal track. Administratively, the officer needs to then file that form. So the defendant gets to keep one copy, another copy is sent to the DMV, and then the defendant has the choice to either have a hearing where they might contest the reason for their arrest, contest the number, or some other challenge that they want to bring up. If they do not contest their refusal, they say, yeah, I did refuse. It is what it is. Their ALS, which is the administrative license suspension, goes into effect. Currently, that's that 180 days. It starts 30 days after your arrest. The reason we have that 30 days, so that somebody could request a hearing if they want it. The form also informs them that it will be suspended starting on the 30th day. If they go to the hearing and the hearings officer determines that there was probable cause for arrest and that there either was the refusal or the blow over the statutory limit, then the suspension is sustained. So it's suspended at that 30 days and it remains in effect unless and until there's evidence that combats that there was a valid refusal. At the same time, so right after you've been given that form, there's also the criminal track. In criminal court, a prosecutor or a law enforcement officer files criminal charges. Usually that will happen the same day of your arrest, maybe the next day. It could be weeks, months, or years, depending on how serious of a DWI. So if we have a fatality and they need to investigate, maybe you're hospitalized or you're seeing if a victim ends up passing away, which would make it more serious, you might not have that charge filed within the first day of your arrest. Once a prosecutor or a law enforcement officer files the charge, you have an arraignment within 14 days. So that is where you learn your rights under the criminal law. You learn the charges against you, and you enter a plea of either guilty or not guilty. At that point, you can go towards trial, or you could go towards a plea deal. Once you take a plea or you are found guilty, you get a criminal license suspension. And that's that 9 months license suspension. This is an example of a first refusal, so just a basic DWI. It would be a 9 months loss of license, 6 months of which may be suspended if you do IDCMP, which is the Impaired Driver Care Management, and the IDEP. So A judge could reduce it down to those 3 months if you've done those steps, but the ALS is still running at that same time. And the reason that we have those laws is because we want to make sure that if somebody is refusing, they have violated their agreement with the state that they would not refuse testing. So they are getting a penalty, not punitive, but a penalty for violating that agreement. Whereas in criminal court, they will deal with the level of evidence, whether the refusal was valid or not. They can challenge all that in the criminal court as well as ALS. So it doesn't mean that you're automatically going to have both suspensions because they are for different reasons. One is your criminal conduct versus one is your civil conduct for refusing to submit to testing. The most important thing, because I know we're almost at 3 minutes, first I want to just clarify the record. I know Attorney McFarland, there was a lot of numbers going around. The 700 plus DWI arrests is from January 1st of 2026. So this year up until yesterday. So within that 3-month time period. At DOJ, I receive the copy of all DWI reduction reports. I also get a report from the courts for all DWI charges filed statewide. In 2024, there were 5,144 criminal DWI cases. We heard from some of the family members that were affected by some of these DWI cases. The question that keeps coming up is, isn't this your third time? Why are you here again? What has changed? Well, what's changed is in 2021 to 2022, New Hampshire was one of the top 5 states for increase in impaired driving fatalities. Other states, such as Vermont and Maine, increased their suspensions. They actually criminalized, which we are not seeking to do, and they saw a reduction. Even though the bill has not passed here previously, DOJ, DOT, DOS, we've all worked together. We make sure that there's saturation patrols, so we're trying to get on the roads more often. We've enhanced our training of officers. We're teaching them how to do an administrative license suspension and properly conduct DWI enforcement at the academy. We're training prosecutors all the time. Statewide, we host regional trainings, online webinars, and send them to other states. We have tried everything possible to reduce our fatality rates, to reduce the number of DWIs, but it is not working. We need to increase the administrative license suspension so that we can actually see that reduction and save lives. Because at the end of the day, this could impact any one of you. We have cases where a little girl is in her house, inside, just skipping around her house, and a car plows through and she ends up hospitalized, almost dead. There are parents just walking their children across the street to a playground. School buses full of children. We could be in this building and somebody could fly in. And so we need to make sure we're strengthening all of our laws so that we don't have to have any more fatalities, because one is one too many. Sorry, any questions?
Seeing none, thank you for your time. Melissa Staples and Matt Howe.
Good afternoon. My name is Melissa Staples. I'm the director of the New Hampshire State Police Forensic Laboratory, and I have with me Matt Howe, who is the supervisor of our breath alcohol unit in the laboratory. I just wanted to take a few minutes to describe the investment that the state has made in the scientific analysis of these samples that would be collected for an alcohol investigation, a DUI investigation. The forensic laboratory supports a toxicology unit consisting of 8 full-time positions, and they're involved with testing blood samples that may be collected in relation with the DUI investigation. What we found over 2025 is that the average blood alcohol concentration was a 0.148, significantly higher than the 0.08 per se limit. And those are the samples that people consented to have drawn. Our breath alcohol unit also supports the calibration and training of the intoxilyzer operators throughout the state. About 7 years ago, we received a highway safety grant of $1.14 million to purchase 134 Intoxilizer 9000s to put throughout the state for use in DUI investigations. A couple of years ago, another highway safety grant supported the purchase of 250 PBT units, also to be distributed throughout the state for DUI investigations. And I would just like to have Matt Howell describe for you a little bit about how they ensure that these instruments are working properly, and also the training of the operators that we do every year.
Hello, thank you for having me here to speak with you. I have been in the breath alcohol unit for about 23 years. I'm now the supervisor, as Melissa said, and have been involved in getting the new instrumentation put into the field and validated and maintained. So we maintain those instruments every 6 months. We certify them and test them at multiple levels of alcohol and electronics to just verify that the instrumentation is still working properly on a regular basis. The instruments are also tested at the time of test. So at the time the subject or the individual submits to the breath test, it is also tested with a standard. The operators are also tested and trained through the breath alcohol unit, in which we train them with an original operator training at the academy, where they have to sit through 2 full days of training to verify that they're able to run a breath test according to our laws and regulations to keep that test as robust as possible. The operators also get a yearly recertification, in which we train those officers and give them any updates and changes that may have occurred in the past year. We also check the instrumentation to make sure that it is working properly, like I said, every 6 months. The instrumentation is also held up by an accreditation. So our laboratory is accredited to an ISO 17025 standard, an international standard that oversees our breath alcohol unit to make sure that we are following the procedures that we say we do. And we are certified to that every 5 years and checked annually in multiple ways. So our program has a lot of robust and a lot of testing behind it to verify and make sure that these individuals that are submitting to breath alcohol are getting a good and accurate result.
So just in summary, I just wanted you to know that the investment that state has made supports the infrastructure that would be necessary for additional testing. And certainly, if this bill passes, we are prepared to accept any additional samples that may come our way in support of having safer roads in the state. And we're happy to take any questions you may have.
Thank you. Seeing no questions, thank you for your
Thank you.
testimony. With that, I'm going to close the public hearing. Thank you.
Oh, I didn't know that.
We are opening the public hearing on Senate Bill 622 and invite the Senator Innes to introduce the bill.
We ready? All right. Good afternoon, Chairman Roy, members of the committee. I appreciate the opportunity to be before you today. I'm Senator Daniel Innes from Senate District 7 in beautiful Bradford, New Hampshire, and 21 other towns. And I'm here to introduce Senate Bill 622 FN. This is a targeted bill that seeks to help protect businesses, governments, and individuals by adding the term entity to the identity fraud section of the criminal code. In this bill, entity is broadly defined to include corporations, LLCs, trusts, partnerships, incorporated or unincorporated associations or organizations, and any other legal entity or combination of entities, including any state, county, municipal government, and any subdivision, branch, department, or agency. Pretty broad. This change would mean that those fraudulent easy pass texts that many of us receive about supposed overdue tolls would clearly be a criminal identity fraud offense. I'm getting some from supposedly the IRS lately as well. Maybe some of you are too. In Section 2, the Senate did make a change. The phrase "or uses personal identifying information" was included on page 1, lines 25 and 28, because in many circumstances, bad actors use an entity's brand, marks, logos, etc., to convince victims of their legitimacy. Thank you again for taking the time to hear my brief testimony. The New Hampshire Bankers Association requested this bill, and they're here today to describe the fraud and bank impersonation schemes that their member institutions are seeing. Before they testify, I'm happy to answer any broad questions that the committee may have.
Seeing none, thank you. Oh, wait, there's one, Representative Muse.
What I'm curious about is whether or not the offenses that this bill would cover are actually prosecutable under other parts of our fraud statute. So where is the gap?
I will be honest, I can't answer that question.
Okay.
I'm not an attorney. I know we have one as a substitute today on the committee, but that's outside my range of expertise. I'm hopeful the Bankers Association will be able to address that for you.
Okay, thank
But
you.
Thank you for the question.
Thank you.
All right, appreciate it.
Thank you.
I'm not, I have to think, I have to sort of look into it.
Christy Merrill.
The answer to that is.
Chair calls Christy Merrill.
Good afternoon, Chairman Roy and honorable members of the House Criminal Justice and Public Safety Committee. My name is Christy Merrill. I have the honor of serving as president and CEO of the New Hampshire Bankers Association. New Hampshire Bankers represents 40 member banks that generate an estimated $127 million in tax revenue for state and local governments in 2024 and support over 17,000 jobs, paying over $1 billion in wages and benefits. And with me today is also our legal counsel, Rob Dietl. Do you want to introduce yourself?
Good afternoon, committee members. It's a pleasure to be here. As Christy Merrill said, I'm Rob Dietl with the Gallagher firm and happy to take any questions.
Did you have some more you wanted to? Yeah.
Senator Innes did a really great job explaining the reason for the bill. Our member banks on the front line seeing this every day, so we're very appreciative of this legislation. I would just highlight that you should all have copies of my testimony. We've included some statistics from the Federal Trade Commission about some of the amounts of fraud. So I won't recite those for you, but just point them out. And I'd also just like to share an article that's included from a bank that's based in Maine that also does business in New Hampshire. And the example is they are trying to get the word out about fraud. There are texts and communications going out that looks like it's from their bank and it's not. And this is exactly what this is designed to address.
Would one of you perhaps answer the previous question the representative put about why our current laws aren't sufficient to deal with this?
Sure. So when we were looking at this legislation, we did a survey of surrounding states and sort of regionally as well. And what we found is that there's some ambiguity in state laws whether or not this specific offense can be prosecuted. There's other tangential laws like theft by deception and things like that that could potentially come into play and cover it. But other states, I think Connecticut in particular, specifically identify that using the identity of a corporation is in fact identity fraud. And so by bringing that clarity into the law, we remove the ambiguity and we make this something that law enforcement, when they look at, will be able to determine quite easily whether or not there's been an offense or a violation. So,
would this apply to any company using the identity of another company? For example, I've had constituents complain about debt collectors who claim to be representing the company who they're not, who they bought an old debt from. Excuse me, would that cover that as well?
If they're doing it without the permission of the entity, then yes.
Yeah, I must.
And there's going to be a fine line. People receive mailings all the time with saying they're looking to refinance loans from banks, and they sort of put the bank's name on there, but you read the fine print. But hopefully this legislation and its clarity will help make abundantly clear that if you take the identity of a corporation without their permission and you use it to impersonate them, that's going to be a criminal offense.
Thank you. See no further questions. Thank you for your time.
Thank you.
Chris Hodgson.
Good afternoon, Chairman, members of the committee. My name is Chris Hodgson. I'm Comcast's Vice President of Government and Community Affairs here in New Hampshire, and I'm representing NECTA, which is the Broadband and Communications Industry Coalition today. That association comprises both Comcast, Charter, and BreezeLine here in New Hampshire. And I'm here to testify in support of the legislation as amended by the Senate. We appreciated the sponsor and the good work of the Bankers Association to work with us on the amendment that was mentioned earlier. And I just wanted to highlight how frequently we're seeing individuals seek to imitate a well-known corporate brand in an effort to seek access to consumer information, make victims of our customers and other businesses' customers, and believe that this legislation will go a long ways towards restraining that type of behavior. Ms. Merrill touched on the degree to which fraud is rampant. My testimony provides some additional information to highlight the cost to consumers here in New Hampshire and New England, and we just wholeheartedly support this legislation and hope that you will find it ought to pass. Thank you for your time. I'd be happy to answer any questions.
Thank you. Any questions? Representative Muse.
The crime that we're talking about, is this what most people think of as phishing?
So it is also an instance when you would misrepresent somebody's identity or brand, corporate brand. So you might reach out to somebody claiming to be Comcast and seek to have them provide you with information that either allows them to access your credit card, your account. You may seek to build legitimacy by representing yourself as a company to access a whole host of types of information. It's that sort of thing. Phishing is it's a particular type of attack, typically through an email solicitation, but this happens via phone calls. It happens, in a whole range of different ways. But phishing is a common type of an attempt to defraud people too.
Not that I don't think this is a good idea, but are not most of these crimes being committed by people in other states or other countries? I mean, have we been able to isolate a lot of the instigators of these crimes to the New Hampshire area? Or?
That's a good question. It's a challenge, right? Pursuing these bad actors is a challenge. People commit fraud, seek to defraud people who are all over here in New Hampshire, seeking to do it to people in New Hampshire and outside, people who are outside the state, outside our borders, trying to do it. You're absolutely right. It is a huge problem. Yep. Thank you for your time.
Anyone else wish to testify? Seeing none, I hereby close the public hearing. And what's the last one? Open the public hearing on House Bill 649. Invite Senator Fenton to introduce this bill.
Thank you, Mr. Chair and members of the committee. Sounds like you guys have had a very long day, so I will be as brief as possible. For the record, I am Senator Donovan Fenton. I represent District 10 in the Senate. And I'm introducing Senate Bill 649, which increases fines and adds license suspension for repeat offenses involving the use of a handheld mobile electronic device while driving, with enhanced penalties when that violation contributes to a crash. Almost every day in New Hampshire, we hear about another crash. I'm sure you folks hear it every day as well. And far too often, those crashes are tied to distracted driving. We see the headlines about families losing loved ones, first responders rushing to the scenes that should never have happened, and communities left grieving for losses that were entirely preventable. Distracted driving is becoming more pronounced, more dangerous, and more deadly. This bill is a strong bipartisan effort to strengthen public safety on New Hampshire roadways. Motor vehicle crashes continue to pose a serious risk to everyone who uses our roads, and distracted driving remains one of the most persistent and troubling contributors of those crashes. The New Hampshire Office of Highway Safety reports that in 2023, we had 127 fatal crashes, and at least six, were from distracted driving. In 2024, we had 135 fatalities, and 135 fatalities, but we don't have the data yet on what was distracted driving, what was not. And this past year, we are already set to surpass that number. All those numbers as a person and a family and a community forever changed, and I think we can all agree that even one life lost is one too many. Mr. Chairman, you and I sit on the Governor's Highway Safety Task Force, and one of our core goals is reducing distracted driving. Over and over, we hear the same message from law enforcement, safety experts, and first responders. The current penalties are not enough to change behavior, particularly with repeat offenses. Current law already prohibits, it's been a long day, guys, I'm sorry. Current law already prohibits the use of handheld mobile devices while driving and imposes fines for violations. 649 builds on that foundation by increasing fines and strengthening penalties for repeat violations, especially when distracted driving directly contributes to the crash. This bill is about accountability, deterrence, and ultimately saving lives. Thank you, folks, for your time and for considering making New Hampshire's roads safer. I'm happy to take any questions.
Thank you. The only question I have is, did you consider the possibility of adding mandatory auto insurance for anyone along one of these three?
I thank you for the question, Mr. Chair. I have not considered that. I would leave that up to your committee to decide on that.
I just didn't want to retread ground that had already been tread. Thank you.
Yeah.
Further questions? Seeing none, thank you.
Thank you. I'm going to zip out. I got to go to another meeting, so thank you all
We
so
appreciate
much.
you spending the day with us.
Happy to be here.
Chair calls Dan Goodman.
Good afternoon. For the record, my name is Dan Goodman. I'm the Public Affairs and Traffic Safety Manager for AAA Northern New England. Thank you very much for the opportunity to speak today. AAA represents more than 1 million members across Maine, New Hampshire, and Vermont, and we advocate for policies that make New Hampshire roads safer. I'm here in support of SB 649. Distracted driving remains one of the most serious and preventable threats to traffic safety. Last year, 3,275 people were killed nationwide in crashes involving distracted driving. That's an average of 9 lives every day. These are tragedies that did not have to happen. Despite widespread awareness of the danger, risky behavior continues. A recent AAA survey found that nearly all drivers recognize how dangerous distracted driving is. 97% say they scroll social media, or 97% say scrolling social media is dangerous. 94% say texting is dangerous, yet many still engage in this behavior. More than a quarter of these drivers admitted to texting while driving, and more than a third admitting to scrolling social media. This gap between what drivers know and what they do highlights the need for stronger deterrence and consistent consequences. Research supports this approach. Studies have shown that stronger penalties, when combined with enforcement and public education, can reduce distracted driving behavior. That combination is very key. We are very engaged in this effort here in New Hampshire. We have partnered with the New Hampshire Office of Highway Safety on a public awareness campaign to highlight the dangers of distracting driving and encourage safer drivers and encourage drivers to engage the Do Not Disturb function on their phone. I also serve on the Governor's Special Task Force on Highway Safety and the Traffic Safety Commission, where reducing distracted driving is a top priority of ours. Across these efforts, there's a clear agreement addressing distracted addressing distracted driving requires a comprehensive approach that includes strong laws, consistent enforcement, and ongoing public education. This is an important step in that direction. By strengthening the penalties, New Hampshire can reduce dangerous behavior and help prevent crashes before they happen. Thank you very much. I'm happy to answer any questions.
Any questions? Representative Muse.
You haven't been here before, so I always kind of harp on this a little bit. But the you mentioned that that to be successful, an approach like this requires strong laws, consistent enforcement, and education. We have a bill that basically provides one thing: the stronger penalties. To what extent do you think it's necessary to get more help from the state when it comes to things like education? And maybe more prioritization of enforcement in order to really make a difference? Or do you think we're just okay with increasing penalties?
Thank you very much for the question. It's a very good question. I commonly refer to traffic safety, things like this, as a three-legged stool. So it's those three things, and this is addressing one of those. But those other two things will happen once the stronger penalties would be enacted. Education would be to organizations like us. I chair on the Governor's Highway Task Force, the Public Awareness Committee. So we work with all of our partners, private and public, on what can we do on a PSA or a radio campaign, or going into schools working with the driver educators. So I think the enforcement, the education, they work with that. So if stronger laws, stronger penalties, enforcement follows that, and education follow that. But they all work together, yes. Does that answer your question?
Quick follow-up. And kind of in an era when a lot of people don't really listen to the radio anymore. You know, they're listening to music on their iPhones. They're listening to all kinds of stuff, not necessarily coming over broadcast television or radio or even in the newspaper. How do you create a public awareness campaign that actually reaches the people you need to reach?
Thank you for the question. Very good question. Last year, the example I'll use, last year we partnered with state and did a new distracted driving campaign specific to New Hampshire. And we did focus groups on New Hampshire teens and young adults. To your point, when we asked them, how do we reach you? Not one of them said television. It was social media, streaming services. So that's where we put our resources. So where appropriate, we will, we do the best we can to reach that audience. Thank you.
That's why I'm a platinum member of AAA.
Thank you very much.
You're welcome. Any other questions? Seeing none, thank you for your time.
Thank you.
Anyone else wishing to testify? Oh, wait a minute, I got a couple more, don't I? Captain Amartucci.
Yes, sir. Thank you, Mr. Chair. Committee members, my name is Manny Matucci. I'm a captain with the New Hampshire State Police, and I am here in support of SB 649. This legislation enhances fines and license suspensions for repeat offenders for using handheld devices and will act as a stronger deterrent. Distracted driving is one of the most prevalent and preventable safety issues on the road. Strengthening penalties for handheld device use can further reduce crash risk, reinforce behavioral change, reflect national standards, and support New Hampshire's mission towards zero fatalities on roadways. And I do have some basic statistics from 2023. There were nearly 28,000 motor vehicle crashes in New Hampshire in 2023, which resulted in 5,048 injured occupants. And of those nearly 28,000 crashes, 4,520 of those, which is a little over 16%, of those non-fatal crashes were a result of distracted driving. And we know that handheld devices is the most contributing factor to distracted driver.
Questions? See none. Thank you. We appreciate it. Oh, wait a minute. Who? Oh, there's no rush. Nothing.
Just curious, have we done anything in the schools or anything like that around distracted driving over the last year or two?
Yeah, so thank you for the question. I know that this is discussed in driver's ed programs. I haven't reviewed all of their curriculum, but my son, 16 years old, just went through a driver's ed program, and distracted driving, impaired driving, those are things that are discussed at length during those programs.
Thank you.
You're welcome.
Yeah, I just have a question. How do you exactly do you define using a handheld device? I use GPS on my phone. What is that okay, or is that what do you have to prove to?
You have to be on your phone, using your phone. If you're touching the radio, if you're plugging in your GPS, that doesn't meet the criteria for a handheld device. You have to be on your phone. You pull up to a traffic light and you look over. Go home today and you look at a traffic light, you will see people to your left and your right. They will be on their phone. They'll be scrolling. It's hard. It's hard to enforce, especially on highways and things like that. But we have saturation patrols. We have targeted enforcements with funding that comes in through the Office of Highway Safety that targeted distracted driving.
Thank you.
When there's a fatality or a serious injury, you're able to subpoena records that are able to prove that they were in fact using the device at the time of the crash, correct?
Yes, sir. Thank you for the question. That's another challenge that law enforcement faces, oftentimes reactively during investigations, during crashes involving serious bodily injury or fatalities. Those steps will be taken where search warrants are applied for and executed on mobile devices or records. But on violations and, I stopped you and I saw you that you were on your phone. No, I wasn't. Oftentimes law enforcement won't go through those steps of seizing a phone, applying for a search warrant for a violation.
Representative Mears.
And under our law, this is a primary offense that you can stop somebody for. So if you see somebody looking at their phone while they're stopped at a traffic light and they go and they're still looking at their phone, you can stop them, correct?
Yes, sir.
Okay, thank you.
Any further questions? Oh, I actually, one just occurred to me. The law is you're supposed to use hands-free. And this, someone told me is what they say is, well, if you get pulled over, say you were activating your Bluetooth. Is that an excuse? That's not an excuse, is it? I mean, you should have activated your Bluetooth before you started rolling, correct?
Yes, sir. Thank you for the question. If cited, that is something that certainly could come up in court, and a judge could determine whether that was, if that person is credible, if they believe that. They'll probably look at history, maybe suspend the fine. Yeah, right.
Thank you. When it comes time for an occasion for us to crack these laws open, I want to make sure that we take care of everything. So if there's anything else you think of, such as that could be or needed to be fixed, now would be the time. Thank you.
Thank you.
Any further questions? Seeing none, thanks.
Thank you.
Anyone else? Anyone else wish to testify? Seeing none, I close the public hearing. What's the last? Don't anybody go anywhere. What's that? All right, if we don't want to come back Friday, I have the amendment for the bill we discussed. It should be ready in a minute. We can vote and go home, or you can come back Friday. It's up to you.
Which bill we have?
I'd rather do it today. We can.
Be okay without
We
Okay, thank you.
Which one is?
621. So that is that one that we're dropping it.
Oh, I see what you're saying. Yes.
Because we have to hear it before we do the amendment.
Yeah, no. I was trying to help you guys. So
I told you we were coming back Friday.
you wrecked it. Farmer took a right turn. With that, everyone, enjoy your night. Stay off your phones. On the way home. Huh? Stay off your phone.
As long as you're not holding it and it's up in the cradle,
It's not here.
We're not doing it.
I did.
We just did the last one for today.